I would like to mention for listing for matter, my lord, admission in the admission column. The matter pertains to suspension and disciplinary proceeding that arises out of the MSc tribunal in Dhubri. Your lordship had entrusted yourself with the matter on the past 3 occasions. Friday. Tomorrow, my lord. Tomorrow might be slightly, but on a date which may be convenient to you.
Next Thursday.
Next Thursday, my lord. I'm grateful, man.
A document for listing admission matter pertains to contractual matter.
Huh?
Admission matter pertains to contractual.
What do you want?
Admission pair for listing matter.
Admission
Matter.
after vacation.
Before vacation, any date matter. It's possible before vacation matter.
Why? Matter pertains to
Contractual bill matter.
My lordship, item number 27, I pray for calling of the record being rejoinder filed in the said case number. The
You have
rejoinder
filed some
is
affidavit.
15 Monday.
You have filed some affidavit.
Yes, rejoinder. It was filed on 15 this 15
You
September.
want to call for the affidavit?
Yes.
Allow.
Not problem. Please, your lordship, I beg to mention 2 writ petition for listing for order.
Orders. Why?
The matter is regarding non-payment of contribution.
After vacation. Not now. Next.
Lord, I'd like to mention WPC number 5392 of 2025 for withdrawal, my lord.
Why?
My lord, actually, the nature of the case is submission of bid and tender. However, the time has passed, my lord.
Withdraw.
Yes, my lord.
Okay, tomorrow.
Yes, my lord.
May I please your lordship? Lordship, I beg to mention item number 28 of today's daily list, lordship. In this matter, lordship, other side has filed their affidavit, lordship. We would like to file our
Who has filed the affidavit?
lordship, Assam State Textbook Production and Publication Corporation Limited, lordship. We would like to file our reply, lordship. We are waiting for instruction.
Interim order.
No, lordship.
Counsel appearing on behalf of the petitioner submits that there is an affidavit in opposition filed, and the petitioner would like to file a reply. Taking into account about 4 weeks' time is granted to the petitioner to file.
Much obliged.
For motion item 1.
May I please your lordship? My lord, after filing of this writ petition, my lord, some development has taken place, my lord. So I would like to withdraw this matter today, my lord. I would like to withdraw this matter today.
You want to withdraw this?
Yes, my lord, with a
The liberty. Why?
My lord, after filing of this writ petition, some development has taken place. My lord, the appeal which we have filed, that we had annexed in Annexer 8, that was rejected, my lord, and an order has been given to us by registered post, my lord. This is the order.
Development is going on.
We have rejected the appeal matter.
So your interest claim has been rejected.
My lord. Yes, my lord, this is the Annex 8 which we have, the appeal which we filed.
In this order, your
Yes,
interest
my lord,
claim
it
has been rejected.
That is why.
Now
I-
you want to challenge this order.
Yes, my lord. The liberty to file.
The counsel appearing on behalf of the petitioner submits that pursuant to that the petitioner had submitted a representation before the respondent authorities claiming interest on the delayed payment. However, by the communication dated, by the order dated 23/6/2025, the claim of the interest was denied. The learned counsel appearing on behalf of the petitioner submits that the said order is required to be challenged, taking into account that without a challenge being made, the present proceedings cannot be proceeded with. She therefore submits that she may be permitted to withdraw the instant petition with the liberty to file, thereby challenging the order dated 23/6/2025. Taking into account the said submission, this court therefore closes the instant petition on withdrawal. Liberty, however, is given to the petitioner to refile, to again approach this court by challenging the order dated 23/6/2025. Petition stands to so and so appears for so and so.
I'm for one and two.
Give your names, they will put.
Item 2,
May Lordship, please.
Yes.
I'm on BSc, my Lord. Lordship, this is a reference, my Lord. And in the reference, initially, we would like to have the preliminary hearing on the basis of the domestic inquiry report. But subsequently, you could not find the inquiry officer in touch and also not find the original records. So therefore, on 15/5/2025, my Lord, at page 43, we have filed an application before the learned labor court intending to adduce evidence on merit. At page
What?
40, intending to adduce evidence on merit.
When?
On 15/5/2025, my Lord, we have filed
Where
an
is that
application.
document?
Page 43, my Lord. Petition number 67. Lordship, kindly have a look at para 1 and 2. On 15/5, the presiding officer was not there. He was transferred. The next date was fixed on 26. And finally, on 14/7, 24/7, my Lord, the impugn order was passed. At page 48.
Now, what do you want?
My Lord, what happened here, without taking into consideration the evidence of the management, employer side and employee side, the learned presiding officer now jumped over to 11A. Lordship is aware that 11A will be considered after the closure of all evidence. There's two judgment of the Supreme Court. Lordship is aware that in the 1973 itself, in the Firestone's case, what would be the effect of 11A? That would discuss,
But tell me,
my lord.
where is your written statement?
Written statement, Lordship, we have filed.
Yes, written statement.
Yes,
Page
page
31.
page 31.
Where have you taken out here that you want to adduce evidence?
No, that we initially we are relied upon our domestic inquiry.
So therefore, without taking it, how is it possible that you
So
are
that-
going to seek a liberty from this court
Therefore,
for
I would like,
adducing evidence that is covered by a judgment of the three judges of the Supreme Court?
therefore I would
Matter
like
is settled.
I would like to rely upon a judgment of the Delhi Ludbut Singh case. my lord.
Yeah, Ludbut Singh is gone. After that, there are 2-3 judgments out there. The
I
three
know.
judgments of the Supreme Court categorically says that you cannot, unless you have already taken that plea in in your written statement.
No, but Lordship, what happened? We are now wants to lead because before closure.
No,
Before
no case. It's a case for dismissal right away. You have not properly looked into the law. These judgments are of no consequences. The matter, there were two, there was one division bench judgment of the Supreme Court, then the matter went to 3 judges, and no, it went to the Constitution bench.
Yes,
There's a
madam.
Constitution bench judgment wherein it has been held that you cannot rely upon.
No,
You
no,
cannot be permitted to file any written statement if you have not taken that plea in your. You cannot be allowed to adduce evidence unless you have taken the plea. If you have plea that in your written statement, it is categorically observed. I think the judgment is by Justice Santosh Hegde. I forgot the name. That day I was dealing with that judgment. P.K. Roy at a case at the appear কৰিছিল সিদিনা. There's a case for dismissal right away at the motion stage. Luckily, you are far away at
No, Lordship.
India, so you won't feel the brunt of getting a dismissal right on your face.
Lordship, there, in the written statement, we have stated all the facts on merit. We have not.
No. Whatever may be, did you take the plea in your written statement? That is not there. That is why I asked you. The law is very clear. সেইদিনা এটা judgment দিছিলো, P.K. Roy appear কৰিছিল. I dismissed his petition on the ground that there was no domestic inquiry, so that question of the Constitution bench judgment would have no implication. তিনটা চাৰিটা Thursday আগতে. So we dismiss it right away. No case.
The similar matter, my lord, also taken up.
You want to face get a dismissal when you are here. Either of it.
Lordship,
This
that's
is not
not
a
the
case
point.
even for issuance of notice.
That's not the point, my lord. The similar matter, my lord, taken up with the Honorable Court. The similar writ petition filed before this Honorable Court, my lord.
When?
This order passed on 16/5/2025.
I had taken it.
No, madam.
Obviously.
Justice
The
Monisha.
law is very clear. Mr. Dotto, the law is very clear. We should dismiss it. P.K. Roy appear. No. This is regarding the Assam Tribune. This person was working as a working journalist. In the, what is his name? I forgot that. Assam Tribune case.
May you take up the matter on Friday, my lord?
You want to have it on Friday?
My lord.
Okay, take it as a puja bonus. A
No,
dismissal.
lordship, mine may be changed, my lord, on Friday. Lordship,
Now,
mind may be
dismiss it
changed.
on Friday, whenever you want, no problem. Get hold of that judgment, I'll dismiss it. That was a case where I distinguished that constitution bench judgment, taking into account that the law would not apply because there was no domestic inquiry. But if there is a domestic inquiry and you rely upon the domestic inquiry, you have to mention in your written statement. And the Supreme Court goes to the extent of saying that when there is a written statement filed, they very well know what are the evidence out there. And as such, it is therefore required that this type of filing of these applications for adducing evidence should not be allowed at that stage. In that judgment, the Constitution bench differs with the judgment in Cooper. I forgot the name of the judgment. Anyways, you want the dismissal on Thursday? Whenever you feel like.
Tomorrow,
When
my
you want a dismissal, I give you the liberty to choose the date.
lord may change your mind. Lord's mind may be changed, my lord, by passing of a day.
When?
On any Thursday or Friday.
No, Thursday. This is not a matter of Thursday.
Friday, my lord.
Friday, yes. This is the matter next Friday?
This coming Friday, my lord. Today is the Wednesday.
Okay, list the at the request of Mr. S. Decker, the learned counsel appearing on behalf of the petitioner, matter stands adjourned to be listed again on 19th of September 2025.
My lord, grateful.
Item 3.
এটা আৱাজটো ভালকে অহা নাই ন আপোনালোকে শুনা পাইছে নে নাই মই শুনা Where is Mr. Who is this? Nobody is appearing. Ish Kumar Sharma. Guwahati High Court is also not being represented. What is wrong? Hello. None has appeared on behalf of the petitioner. This is the matter of the vacations. None has appeared on behalf of the petitioner as well as for the Guwahati High Court. List the matter.
Lordship.
Yes, what is this?
Lordship, this,
Payment.
yes, Lordship, non-payment.
How much?
Lordship, 93,15,627.
Only.
Yes, Lordship.
And similar situated persons have got reliefs
Yes, Lordship.
because of orders
Connector
passed.
9, 10, 11, Lordship.
Huh?
Connector 9, 10, 11. 3 orders are there.
How many months it has been given?
In the month of March,
Yes.
order dated 25/3/2025. Start from page 49. Paragraph number 3 and 4. The standing council of respective departments has admitted that there are some sanction from the government, Lordship, and that payment can be made from that sanction.
Matters on contractual bills, senior advocates are appearing. Anyway,
Part payment was made, Lordship, initially.
good. I should support you. You have taken the courage of appearing.
Lord,
Senior advocates.
Issue notice, my lord, please, because
Yes.
in
Yes,
that
yeah,
case it was
no.
admitted.
Issue notice making it returnable. We dispose it of this year.
No.
Issue notice making it returnable on 8th of December 2025.
I appear for 2.
Mr.
Standing council is there, madam. For agriculture department, they are standing council.
B.
Which
Chaudhary.
yes.
Have you seen him around in the corridors?
Yes.
Mr. B. Chaudhary appeared on behalf of
1, 3 and 4.
1, 3, and 4. Even for Assam seats.
Oh,
Assam seats is
yeah, it will be
Mr.
the-
Samaria, na?
Yes, ma'am. 1 and 3.
Mr. Samaria is a standing council.
SIPO person থাকে নাকি?
Assam Seats Corporation.
Substitution Corporation Lordship, they have taken the copy of response number 3 and 4 by the Agriculture Department. Lord.
Okay. Mr. B. Chaudhary accepts notice on behalf of the respondent numbers 1, 3, and 4. And what is it? 5 also, nodal officer, Rashtra
Five perhaps
Kushal, huh?
formal party, I may be allowed to strike off. This is not a
1, 3, and 4. Mr. B. Gogoi, the learned additional advocate general, is well. There he comes, Mr. B. Chaudhary.
This general,
You accept notice on behalf of what?
MD के लोगों, सिख को MD सिख को that's why.
he would is
No, Sikh Corporation Lordship, there is another standing council.
Mr. Samaria, no?
Yes, Lordship.
Okay, you give a copy to him. Mr. Bigo Chaudhary accepts notice on behalf of the respondent numbers 1 and 3. Mr. B. Gogoi, the learned additional advocate general, accepts notice on behalf of the respondent number 2, as he is the standing counsel of the finance department, the government of Assam. The learned counsel appearing on behalf of the petitioner submits that there is a standing counsel of the Assam Seeds Corporation. Taking into account the above, this court directs the counsel appearing on behalf of the petitioner, extra copies be served, to serve an extra copy of the petition upon Mr. S. Samaria, who is the standing counsel of the Assam Seeds Corporation Limited. As regards the respondent number 5, the learned counsel appearing on behalf of the petitioner submits that his name may be struck off, as he is not neither a necessary nor a proper party to the present proceedings. Accordingly, the name of the respondent number 5 is struck off. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court and file an affidavit of, and on the basis thereof, within 3 days, and on the basis thereof, within 7 days, and on the basis thereof, the registry shall make necessary changes in the cause title and update in the CIS. The case of the petitioners herein is that the petitioners supplied seeds, supplied certified groundnut seeds to the respondent authorities. What? When was that? When did you supply?
supply order was Lordship 28/9/2020, wrongly mentioned here, Lordship, 28/9/2022.
22. Where is the supply order?
Supply order is the director of agriculture. 24, yes,
Have issued, have
2020,
petitioner
Lord.
herein
28/9/2020.
in pursuance to the order issued by the respondent number 4 for supplying dated 28/4/2020,
So it's 9, Lord.
28/9/2020. The petitioner had supplied certified groundnut seeds under the flood damage restoration under the disaster management 2020-21 within the time stipulated, isn't it? Did you supply
Yes, yes.
within the time stipulated
Yes,
or
yes.
not? Within the time stipulated. That is 10th of October 2020. The petitioner thereupon submitted the necessary bills amounting to rupees
2 crore.
2 crores 27 lakhs 80,755. And out of which rupees 1 crore 34 lakhs 65,128 was paid to the petitioner on 8/4/2022. The petitioner claims that a further amount of rupees 93 lakhs 15,627 is pending. and therefore submits and pending. And in spite of various representations being submitted to the respondent authorities, the payment have not yet been made. It is under such circumstances the present petition has been filed. The respondents herein are directed to summary duta copy dibo lagbe duta. The respondents herein are directed to file their affidavit. As we bring on record the stand by filing the affidavits as to whether the petitioner is entitled to the amount so claimed. And if so, when the said amount would be paid. Justo. The said affidavit be filed on or before 3rd of December 2025.
This pendency shall not be a bar.
What?
Pendency of the writ petition shall not be.
During the pendency of the writ petition, no payment should be made. Don't come up with that. When you come before this court, then don't ask them. I'll pass an order whenever it is necessary.
Item 5.
Nelly. Yes, Mr. Hawk.
Well, it matters.
Whenever I see the petitioner's name, I even don't look at it. Who is the lawyer? It's Mr. Hawk. Yes. What is the non-payment?
No, my lord, it's
Oh,
a
site verification.
non-renewal of license, my lord, permission.
Renewal of?
Renewal, my lord, of Eastern Kesher, my lord.
Huh?
It's non-renewal of permission, my lord, of Eastern Kesher, my lord. Here, when petitioner had submitted the application, my lord, along with the other required document, page 16, my lord.
For running the crusher machine.
Yes, my lord.
Where is it?
My lord, it is at, my lord,
Nolbari.
Kudrakatar, my lord, yes, Nolbari.
They have not granted the renewal,
Yes, my lord.
isn't it?
My lord,
You agree by the non-granting of the renewal.
yes, yes.
When did you apply?
Uh,
You have all made all the payments also.
yes, my 23.
Yes, Mr. Bhattakur. What is this? Why haven't you granted him the renewal?
There is actually, my lord, a linked case of the petitioner, my lord.
Huh?
The petitioner is the husband of the petitioner in another case, if my lord is aware. There is a case called Parvin Sultana versus State of Assam, my lord. The writ petition 50 of 2025. There, my lord, some action has been brought against the establishment. That is why, but I'll take instructions, my lord. I'll take.
That is
written instructions.
potentially brick clean value. That is separate case. That potentially brick clean, another matter.
I'll take instructions.
They are
Yes.
taking everything.
Petitioner herein is
Your-
one of the biggest contributors of litigation isn't it?
Yes, madam.
Yes. See,
Well, actually, well, he is think made to suffer. Well,
he is to suffer.
yes, madam.
And that is to the benefit of Mr. S. Hawk.
No, madam.
Yeah. I even don't look into anything. I see the name of the petitioner, it is Mr. S. Okay, issue notice. We have it in the month of October. Issue notice making it returnable on 17th of October 2025. Mr. Thakur accepts notice on behalf of the respondent numbers 1 to 4. Mr. S. Burwa accepts notice on behalf of the respondent number 5. Extra copies of the writ petition be served upon them during the course of the day. The case of the petitioner herein is that the petitioner is the owner
Right.
of a stone crusher unit in the name and style of MS Pasha Construction, which is situated at village Kundra, Katara, under Moza
Batagila.
Botagila in Nolbari district. The petitioner was granted the permission to run the said stone crusher unit up till 31st of December 2024.
My lord.
Thereupon, the petitioner submitted the renewal application on 23/4/2025.
My lord.
But on account of not granting the renewal permission In spite of approaching the respondent authorities time and again, the
Right.
petitioner has therefore approached this court by filing the present writ petition. The respondents are directed to bring on record their stand by filing the affidavits on or before 14th of October 2025 as to why the petitioner have not been granted the renewal permission. List
Okay.
record.
Right.
Item 6.
Yes,
My lord, this is regarding non-payment of bills regarding hire of vehicle.
non-payment of,
Bills.
oh, police.
Yes, yes, my lord.
Issue notice making it returnable on 15th of December 2025. Miss Yuda accepts notice on behalf of all the respondents.
Except two, my lord. Two is final.
Accept notice on behalf of all the respondents except respondent number 2. Mr. B. Gogo accepts notice on behalf of the respondent number 2. The case of the petitioner herein is that the extra copies be served upon them within 2 days. The case of the petitioner herein is that the petitioner is the owner of a vehicle bearing registration number AS09F9399, which was taken on hire by the district administration of Karbi Anglong
West of it.
East. West.
West.
Karbi Anglong West district administration was taken on hire by the district administration of Karbi Anglong West. However, for different periods from 4/3/2021 to 31/5/2023, the petitioner had the total bill to which the petitioner claims to be entitled to is rupees 13,23,469. It is the case of the petitioner hearing that the petitioner had approached the respondent authorities on various occasions. However, no payment has been made, and under such circumstances, the petitioner has approached this court. The respondents are directed to bring on record their stand by filing their affidavits as to whether the petitioner is entitled to the amount so claimed, and if so, when the said payment will be made. The affidavit be filed by 8th of December 2025.
Item 7.
Outstanding bill, my lord. Boarding fuel has been
I
done.
vote Thakur accepts notice, issue notice making it returnable on 17th of December 2025. Mr. Ivo Thakur accepts notice on behalf of respondent numbers 1 to 4. Mr. B. Gogo, the learned additional, the standing counsel of the finance department accepts notice on behalf of the respondent number 5. Extra copies of the petitions be served upon them within 2 days. The case of the petitioner herein is that the petitioner was allotted the work. Petitioner number 1 was allotted the work for installation of a DTW with DTH reed boring of 200 mm into 150 mm size at Gormora Satra, Adoroni Port and Cabin Chowk PWSS. The petitioner claims to be entitled to an amount of rupees 28,42,407, and the same having not been paid, the petitioner have approached this court by filing the instant petition. The respondents are directed to bring on record their stand by filing their affidavits on or before 10th of December 2025. as to whether the petitioner is entitled to the amount so claimed, and if so, when the said amount would be paid. Yes, FT, D voter.
Yes.
D voter.
Yes, my lord.
Yes.
He has been shown to be a D voter, my lord, right from 2011, my lord.
Huh?
He has been shown to be a D voter, my lord, right from 2011, my lord.
Dispose. Dispose.
Yes.
Nine.
The order. You have the orders now?
Yes, your
Give it to them along with which is the voters list, which year,
2000.
constituency, and the SP voter.
Oblige, your lordship.
In this case, also earlier they have approached. In this the voter case, earlier they have approached one.
Which one?
Yeah, earlier one, item number 8.
What is that echoing sound?
So you can come here.
What is this?
They have earlier approached, direction was there.
Earlier approach for what?
Page 29, Lordship Annex.
No, your matter, na? You
Mine.
are this Matlab Ali.
Yes,
my lord. My matter.
page 20.
Agree by the regime.
Yes.
Yes. If this is the order, why haven't you send it now, till now, Mr. Bolo?
Lordship, that has to be taken care of by the ST, Furnace Tribunal. Standing Council is there.
Foreigners tribunal, no. This has to be done by the SP border.
Yes, they are represented by the
SP border.
SP border represented by the ST, Furnace Tribunal, Lordship.
Then where is
Standing
it?
Council.
Hello. We asked the SP border, Kokraja, to appear in person.
Can it be
It's a
after
very
some time,
serious
Lordship?
thing. No. We
After
appear-
some time, I will inform the Mr.
No.
J.
This is
Pine.
very serious. This is a case of violation. Leho, issue notice making it returnable on 26th of September 2025. Mr. S.R. Bolu, union no. None appears on behalf of the respondent number 1, and Ms. P. Borua appears on behalf of the respondent number 2. Mr. S.R. Borua appears for the respondent number 3,
Not a five, Lordship.
respondent number 5.
Lordship.
None appears for the respondent number 3, 4, and 6. So 1, 3, 4, and 6. Full stop.
Returnable date to be there.
Taking into account, is there a standing council of the NRC?
NRC, I think Unit of India Council represents as of now. NRC? Is there? Who know? J. Pine itself. Mr. J. Pine.
And who appears for superintendent? J. Pine.
J. Pine.
And Home Department
In foreigners cases, he J. Pine.
and Ministry of Home,
Yes, home.
Union of India.
Union of India, that.
Taking into account the above, this court directs the counsel for the petitioner to serve a copy upon the Mr. Who is the DYSGI? R.K. Dev Chaudhary,
Yes,
upon Mr. R.K. Dev Chaudhary, the learned DYSGI. Gustav, it has been also mentioned that in respect to the respondent number 3, 4, and 6, Mr. J. Pai is the standing counsel who can represent the said respondents. Extra copies of the writ petition be served upon him during the course of the day. The petitioner herein is the petitioner herein claims to be an Indian citizen, but his name was shown as D,
Yes, my lord.
shown as a D voter in the electoral rolls published in the year 19,
2011, my lord.
in the year 2011. Full stop. The petitioner being aggrieved had approached this court by filing a writ petition being WPC number 1106/2021, whereby this court had passed an order on 9/4/2021, thereby directing the superintendent of police B. Prajar, who is the respondent number 6 herein. 6 herein. To make due verification and if necessary to refer the petitioner on his approach to the concerned foreigners tribunal in order to examine the various documents to be submitted by the petitioner and pass appropriate opinion in that regard. It was further directed by this court that the said exercise be completed within a period of 60 days from the receipt of the said order. Did you approach pursuant thereto?
Yes, my lord.
The counsel appearing on behalf of the petitioner submits that the petitioner duly produced the certified copy of the order dated 9/4/2021 before the respondent number 6. However, nothing has been done in that regard, and the petitioner name continues to remain as a D-voter in the electoral rolls. It is under such circumstances the petitioner is compelled to approach this court for the second time. Full stop. The respondent number 6 is directed to apprise this court as to whether on the next day, without fail, as to whether actions have been taken in pursuant to the order dated 9/4/2021 in WPC number 1106/2021. And if so, what actions have been taken? Full stop. Ms. P. Volva, but the learned standing counsel of the Election Commission of India is also directed to obtain instruction as to what steps have been taken by the electoral officer. What is that?
ERO,
No, not the chief electoral officer. There will be another one below that.
Deputy Electoral.
The DEO.
Yes.
The
DEO.
district electoral officer, as to what steps have been taken pursuant to the order dated 9/4/2021 in WPC number 1106/2021 on the next day without fail. It is on 26th of September. You give a copy to this
Yes,
as well as order.
Okay.
And next time superintendent does not appear, we take it. Anyway, Mr. S.K. Singh, what is this?
This is also similar matter as item number 6, man.
Huh?
This is a similar matter as item number 6. This is also payment of bill, man.
Payment of bills.
Yeah.
এইটো সেইটো লিখি দিব এই আগৰ এটা লিখি
Six.
দিব নহয় কিবা এখন গাড়ী এখন ইয়াৰ গাড়ী নম্বৰটো বদলাই পেলাই এইটো হ'ব. And why are you approaching this after 6 years? Where will they file anything?
We've been approaching the authority time and again.
No. You cannot. This type of cases has to be dismissed. You cannot. These are 2019 bills. I'm not going to issue notice.
No, we have submitted, my lord.
Sorry. Where is it and any acknowledgement? Show me that.
Good.
Any acknowledgement. You cannot after 2023,
We have been.
19 you supply and they may lose all the records. Isn't it, Mr. Burwa?
Yes, Lordship.
Yes, you will obviously say.
Matter at that time, the corona.
No
was there.
case. This is a case for dismissal right away.
No, at that time, corona was going on, that's why.
No, there cannot
No
be.
possibility.
If you are supplying, you supplied from 1/3/2019 to 3/9/2019. The earlier one I allowed because of those were done up till 2023. We have approached within a reasonable time. But this I'm not going to allow. I'll dismiss it right away. You do one thing, approach them, get something out there, acknowledgement, then approach. Better off. Otherwise, I'm going to dismiss. I'm not going to allow.
Because of Corona, it was going till.
What?
Corona period. That's
What
why.
Corona period? Corona had not come even in China at that point of time when you supplied.
After that,
Then
we did not approach because
everybody could come and you are now taking the benefit of Corona. No case. Lekho. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.R. Borwa, who appears on behalf of all.
No, no, except two, Lordship.
Appears on behalf of respondent numbers, all
One.
the respondents except respondent number two.
Two.
Mr. B. Gogoi, the learned additional advocate general, appears on behalf of the respondent number two. The petitioner herein has approached this court seeking a writ in the nature of mandamus, thereby directing the respondent authorities to pay an amount of rupees 3,68,857, which the petitioner claims that the said amount is due by the respondent authorities and have been duly acknowledged. Full stop. This court finds it very pertinent to mention that the petitioner claims that the said amount is due for the hiring of his vehicle bearing registration number AS026575 for the period from 1/3/2019 to 3/9/2019. This court inquired with the learned counsel appearing on behalf of the petitioner as to where there is any acknowledgement to show that the petitioner's amounts have been, that the amount so claimed by the petitioner has been acknowledged by the respondent authorities. The learned counsel appearing on behalf of the petitioner could not show any such document in that regard. Full stop. This court further takes note of that filing of a belated claim, as in the instant case, after 6 years from the alleged claim that the petitioner has made supply, and if any direction is also issued for consideration, comma, the respondent authorities loses their legitimate right defense on account of a belated claim. Considering the above, this court is not inclined to issue notice in the instant proceedings for which the petition stands dismissed. Liberty, however, is given to the petitioner to approach the respondent authorities if so advised.
Okay.
And
Yes, what is this?
Lord, petitioners were blacklisted, my lord, initially, and
You've been blacklisted.
blacklisted, my lord, without following
Full
the
uniforms.
due procedure.
Your period is over.
Now, we have submitted the tender quotation, my lord, but the as the
Then
other
how did you submit?
school wise, my lord, they have accepted. The school committee has.
But you could not have been enrolled in the Shiksha Setu.
This honorable court, in case of other bidders, my lord, has to give that.
Other bidders, the court has passed an order.
Yes.
But where is yours?
There is no order prior to
Then
that,
without that, unless you don't qualify as per the guidelines of 18.8, na?
H1D.
Huh?
H1D.
No, no, 18.8.
8 August.
2020.
8.
8.8. You don't
Yes.
qualify unless you qualify in terms with without enrolling yourself in the Shiksha Setu. Where is the question?
Yes,
Okay, it's bad case.
and we have submitted, my lord, the quotations they have accepted in the school.
No. Quotation they could not have accepted. You reject the quotation, right?
Yesterday was the last date, Lordship, for issuance of work order, Lordship.
That
was-
I know.
Yes.
But how could they accept?
Except they can accept, but it will not be considered.
No, they cannot accept because of the guideline. Where's the guideline?
Guidelines.
Unless he challenges that guideline.
This under challenge here, my lord,
Where's
page,
the guideline?
page 51, my lord.
Page?
If it starts from page 45, it's relevant page 51.
Page. No. Where's the guideline?
Page 50, Lordship.
Ah, yeah. got it. Yes, page 50. Only those vendors who are registered in Shiksha Setu will be allowed to participate. Those persons were an exception. You are not, where you are part of.
My lord, we have registered, we have got another farm, my lord, in the, again, same GST number, we have got two farms. We have registered in the other name, my lord. It's a Tiwari Enterprise as well as, my lord, JS Enterprise. We have registered in Shiksha Setu.
So that is not blacklisted.
That is not blacklisted.
Then what is your problem?
But yes, because the same GST number is same, my lord. Therefore, my lord, our tender is not possible.
How can there be two GST same number? No, it cannot be. Your GST number is different. See, on top, page 3. Khan Enterprise GST number is ending with 3Z5. And this ENT Enterprise is 271.
Because of the same person, sir, because the proprietor is the same, my lord.
Proprietor, maybe GST numbers are different.
Yes, proprietors are same, my lord, therefore they have not processed. Proprietor is the same person, ultimately, my lord, supplier. Therefore, my lord, yes, because the schools, they know the proprietors. Therefore, my lord, they have not issued the work order in favor of, though they have accepted but kept it pending. So my humble submission, my lord, wherever they have submitted and wherever the work order has not been issued, their case may be considered, my lord. That's
And it has been given to somebody else.
it is in some schools it is given, in some schools it is not given. It is school wise, my lord.
Now, what do you want?
My lord, wherever this schools has not given the work order to anyone, my lord, is pending. In that case, my lord, our cases may be considered, my lord. That is the
What?
the schools where, my lord, the work order has not been issued yet, my lord, and our tender is submitted there. And in respect of those schools, my lord, our case may be considered. That is
Whose case?
this petitioner's quotations may be considered.
First of all, Khan could not. Khan was not, Khan Enterprise was not enrolled, participated in the, is not
Shiksha.
enrolled, registered
Shiksha.
under the Shiksha Setu.
No.
ENT Enterprise is. So they, you say they can be considered,
Yes,
but not Khan Enterprise.
Khan Enterprise.
Khan Enterprise, you cannot.
It is
He has no case.
Khan Enterprise.
He has violated it. And ENT, they will consider as per law. What do you say, Mr. Nayak?
Lordship, first
Why
Lordship,
should I pass any order in this regard?
and
Consider, not
moreover,
consider.
Lordship,
That is absolutely.
moreover, Lordship,
If they don't consider, you will have a cause of action.
yes, Lordship.
No case.
Moreover, so far as other entity is concerned,
It's an apprehensive litigation.
But by this time, already time will be over because the supply will be done.
it's already over.
So if the supply is already over, you have come on after 15 line. Can't help it. No, no come. $15.9 is the last date
Yes, yesterday.
for open tender. Then we have come later. That case. Why should we consider? You filed it on 15/9.
Yes.
Then look. You come when you are aggrieved. As of now, you are not. Is it on? It's the word of the mouth. When there is anything in black and white, come over. That is the withdraw with liberty to come when there is anything in black and white. That is a better option. Okay. What do you say?
Lordship, so far as the other entity whom he is claiming that he has already registered himself, that is also not in the repetition lot. Wherefrom we will, confirm that one entity has been registered, one other is not. That is also not there.
No case.
In fact, Lordship, he challenged the guideline itself, Lordship, that
Oh, you have
requirement of
challenged H1.
registration. Yes, H1D.
So we'll consider. I think this is a fit case for issuance of rule. Don't you think so? We'll take
Not-
it up after the 31st of December is over.
Not-
Issue rule.
Notice maybe.
And if I issue rule, then the thing is, once the matter is pending, you can't file another one. What do you want?
I leave it to listen.
You don't leave it to me. I'm giving you options. You leave it to yourself. But this is not a case. It's a serious case. And those cases where I passed an order, these cases I have not passed an order, but I passed one order where it was the categorical submission of the petitioner that those defective clothes which were there were taken back
Yeah.
and good clothes and proper as per specification was handed over.
Yes, that is done by us also.
So therefore, in those cases, I passed an order that too, the order came out around 6 o'clock in the evening.
And on that day itself, Lordship, we issued registration.
Huh?
That day itself, Lordship, we issued registration in
Ah.
respect of those
There.
petitioners.
But here you can't help you.
We have
came very late.
replaced, we have also replaced the mallet for defective
But I
items.
can't help you. You have come late. You approach. Why? You couldn't have approached. So, you issue notice, no stay,
Lordship.
nothing, no order, not even a prelude which I pass in an order. That is also not necessary.
One line, Lordship will clarify.
Huh?
One line, Lordship will clarify.
I'll say issue notice. Not even this case is not entitled for anything more. Issue notice making it returnable on 17th of November 2025. Mr. Pinaik
For two Lordship.
accept notice on behalf of respondent number 1 and 2.
Two Lordship is SSA Lord. One
Huh?
is department, education department.
Oh, elementary again. You have copied and pasted that Mr. B. Shetty's petition. Here also says same mistake. Isn't it?
Yes, Lord. The first thing I noticed, Lord.
I have taken from him through email, my lord.
Ah, see,
I admit
I
it.
say, because he also made the mistake. I told him, how can there be a commissioner and secretary of elementary education department?
I copied it from email, my lord. I admit it.
Yes, who can appear for this one, elementary? You are the additional.
I can appear. Lord.
Mr. Pina, who is the additional advocate general, accepts notice on behalf of the respondent numbers 1 and 2. Extra copies of the writ petition be served upon him within 2 days. The case of the petitioner herein is that the petitioner number 2 had supplied petitioner number 1 or 2.
Both, my lord.
Petition number 1 and 2 had supplied school uniforms during the period 2023-24. You have another set of petitions today? No, no. There are so many tick marks. That is why I'm. And do you come in that list?
Yes, lordship.
Where is that?
And paste the 30 serial number 22, 20.
So these are all the negative lists.
Yes, lord.
And it was found that the petitioners herein did not supply the school uniforms as per the specifications laid down in the guidelines. It is the case of the petitioners that thereupon the petitioners remedied their mistakes and supplied and thereby replacing the faulty uniforms. On 8/8/2025, the respondent number 2 had issued certain guidelines for the purpose of procurement of preschool uniforms for all children from class 8 of government provincialized LP, UP and composite schools elementary level by the SMC/SMDC. In the said rules, in the said operational guidelines, it has been mentioned, amongst others, that only those vendors who are registered in the Shiksha Setu would be allowed to participate in the tendering process. And further to that, those vendors who were blacklisted due to supply of substandard quantity of uniform during the year 2023, 24 and 24, 25 shall not be considered to participate in the tendering process and also in the quotation process. It is, however, very pertinent to take note of clause H1 small e, which stipulates the time schedule. Inasmuch as the work orders pertaining to more than 1 lakh, there is a requirement of a short quotation, and this work and the work orders in respect thereto has to be issued within 15th of September 2025. By way of open tender process. Where is your statement that you are registered under the Shiksha Setu? Not there. Not there, because you have copied that petition.
In the cost title, I have given the registration number.
GST and ho. You are registered with the Shiksha Setu.
Shiksha
not
Setu
there.
number is given, my lord, in the cost title. I have
Where?
given. SSRM, SSVR number
When did you get this? Earlier?
earlier.
No, as you now.
Yes, it's required every year, Lordship.
Every year.
Yes.
In H1E, the time schedule is so and so by open tender process. This court further finds it that the grievance of the petitioner herein, that the petitioner's application, petitioner, though have been permitted to participate, but their cases would not be considered in view of clause H of the guidelines dated 8/8/2025, and as such have challenged clause 8H in the present proceedings. Petitioners have also sought for consequential reliefs as regards thereby as regards directions be issued that the case of the petitioners be considered by the concerned authority. This court finds it very pertinent to take note of. At this stage, this court takes note of the per contra, Mr. Pinak, the learned additional advocate general, on the other hand, submits that the petitioner has approached the court by filing the writ petition on 15/9/2025, which is the last day for issuance of the work order. The learned counsel further submits, the learned AG further submits that every year there is a requirement of registration in the Shiksha Setu. And there's no a single averment made that the petitioner have for the present year registered in the Shiksha Setu
Or even apply.
or even applied. Or even applied. Under such circumstances, without such registration, the question of the petitioner being permitted to participate does not arise. He therefore submitted that this is not a case wherein the orders passed by the learned coordinate benches can be applied inasmuch as those orders were passed much prior to 15/9/2025. This court have duly considered the rival submissions and is of the opinion that the question of issuance of any interim directions at this stage does not arise. However, the respondents are directed to bring on record the stand by filing the affidavit on the legality or validity of clause 8H of the guidelines dated 8/8/2025. The said affidavit be filed on or before 7th of November 2025. Liberty given to the petitioner to file reply thereagainst.
One specific provision, Lordship, H1D.
He is only challenging H1D.
Yes,
Not other.
not others.
You
Only
have to challenge the Shiksha Setu also.
that requirement only. That requirement only, registration under 6.
You need to do it. Very poorly done.
Obliged, Lordship.
Mr. Pugasta, why don't you withdraw and file a refiling? Because without that, you have a difficult.
But I will
At the end of the day, you will lose the case. There's no way. H1D would not come into play unless H1C, B is there. You have to challenge that you have to enroll every year in the Shiksha Setu.
I will consult with my client there.
Otherwise, this order goes.
I will mention.
It's okay. Then goes for us.
May please, your
Yes, what is this?
my lord, the petitioner, my lord, entered into a written agreements with the respondent number 7 for purchase of two tea estates, my lord.
What?
Two tea estates, my lord.
Purchase of two
Tea estates. Now, my lord, in this area, my lord, final deed of sale deed has not been executed as yet. Now, what happened, my lord? In those agreement for sale, there were cut-off dates mentioned, my lord. And as per the cut-off dates, my lord, pursuant to the cut-off dates, whoever the employees of the respondent number 7 came under the management of the petitioner, my lord, were to be paid gratuity, bonus, everything, all incidental service benefits, which was done, my lord. Even those persons who have retired under the management of the petitioner, I have bring that record also, my lord, were paid gratuity, my lord. Now, what happened? 10 persons, my lord, who claim to be the erstwhile employees of, my lord, the respondent number 7, they said that they were getting pension from the respondent number 7 and they started claiming pension.
How did you take this garden?
Lordship,
How did you take up this garden?
my lord, only agreement for sale has been executed.
How can there be an agreement for sale of a garden?
My lord, sale deed has not been done, my lord. That is the exactly, my lord, may I just place the further facts, my lord. Now, what happened? When those 10 persons froze for payment of pension, the plea that was taken by the
Payment of?
payment of pension, my lord,
By?
by the petitioner, my lord.
These are workmen?
these were employees, not even workmen, my lord. They are employees. They are staff, my lord, like my lord, the clinical staff, my lord, the technical staff. They started 10 numbers of incumbents, my lord. They started claiming pension. The
Pension
petitioner,
is given under what provision?
yes, my lord. They say that in 1977, the then management of the tea garden, which was a separate company altogether, had entered into an agreement with Assam Sah Kormosari Sangha, and which is a trade union. And pursuant as far in terms of that agreement, my lord, now the garden owners were liable to pay pension. So, my lord, the plea that was taken by the petitioner in front of them, that see, this is the liability of the respondent number 7, and the pension has to be paid by the respondent number 7, not the petitioners. And there is no provision in the agreement for sale or any document that has been contract that has been executed between the parties to pay these pensions. Now, my lord, this issue culminated into an industrial dispute, my lord, and the Assam Sah Kormosari Sangha took up the matter to the, my lord, industrial tribunal, my lord. In the industrial tribunal, the petitioner before your lordship, they filed an application.
It was a two-way application.
No, lordship, yes, no, only one reference was there.
Was the reference made by the government or was it a two-way reference?
Reference was made through the government.
So under 10.
Under 10, through the government, my lord, by Assam Sah Kormosari Sangha. And in that case, after getting notices, my lord, the petitioner appeared and they filed an application for implement of the respondent number 7, saying that it is a necessary party, my lord. Implement was done, my lord. Now, responses were filed by written statements were filed by all the parties, and my lord, the entire matter was heard. Surprisingly, my lord, the industrial tribunal records a finding that the petitioner's lawyer has consented to payment of pension, my lord, which he didn't do, my lord. The petitioner later on, after receiving copy of the award, took instructions from the lawyer who had represented them, and he also said that what he had pleaded was for payment of gratuity, not of pension, my lord. If your lordship peruses, my lord, page number 185, the relevant portion of the award, my lord, page 185, paragraph 28, my lord. Shall I read, my lord? The learned counsel for Mocha Tea Estate Private Limited admitted that they have not paid pensionary benefit to the retired employees since November 22, and now they are agreed to pay all the remaining dues to the retired employees as pensionary benefit. Well, after receiving the petitioners directly took instructions from the lawyers where from this submission had come. When, my lord, in the written statement, 2 written statements were filed, my lord, the claims were totally, my lord, contested, saying that these are the liabilities of the respondent number 7, my lord.
Where is that instruction sought for?
Lordship.
Instruction sought for, where is it? From your lawyer?
My lord, that was telephonically taken, my lord.
What telephonically?
My lord,
Everything is telephonically.
my lord, no, lordship, one thing, my lord. We would have, my lord, the petitioner would have filed a review application, my lord.
File a review.
My lord, but the provision of review is not there, my lord.
Procedural review. There's always, see the ANZ Greenwich judgment 1982.
Lordship, since that review will not be entertained by the industrial we are before your lordship. My lord, may I just pray? Let it be remanded back for once, my lord.
No.
Let it decided on merit, my lord.
You have agreed. You should have enclosed that particular lawyer says that I have never said it, because otherwise he has stated. That was the argument made.
My lord,
I will give it.
even then, my lord, 2 written statements were filed.
So
Where
what?
categorically stand was taken. This is the liability of the respondent number
Take
7.
action against that lawyer. That why on earth the lawyer had taken it. Then only we can issue.
True, my lord, true. My lord,
Take action against the lawyer.
when the lawyer has also stated that he has not made, he never made this submission, my lord.
Rahul, question does not arise unless you take action against the lawyer. You don't take action. You even there is no documentary evidence to the show that you have passed the law. Okay? If you can do so in such a manner that okay, I telephone this lawyer and did you ask that, then you will say no, matter ends there. Then we are to disbelieve what is there, but there is nothing on record. Take action against the lawyer. File a that he has mentioned this. Let him say before the bar council. Then only we'll say that, okay, you are bona fide.
I know what has fallen from your lordship, but my lord, when my client inquired from the lawyer said he never made this submission.
How do I
That
know?
is why the occasion
How
of
do I
this
know
re-
the lawyer, your client inquired?
My lord, it is statement made, my lord.
So,
I have made the statement in.
and the lawyer said, how the lawyer will all hearsay.
My lord, no. What is it, my lord? In the written statement, we have taken a stand that we are agreeable to pay the gratuity as per the agreement conditions. Now, what the lawyer told my client, my lord, the
Not
submission
satisfied.
that he had made was for
Mr.
payment of
I
gratuity,
will
not of pension, my lord.
Not satisfied. You take action and come. I will, in the meantime, take action against the lawyer. Then we and bring on record by way of an additional. Bring on record something. Why should we? Let the lawyer say or not that I have never said that. He's not stating anything on board. That I have never made that submission. Then only a case will be
No,
there.
that-
Where is
in
the
fact,
basis?
that is the, if your lordship peruses the other plea, for a moment,
I'm
my
not going to look into other.
my lord,
The basic question is on that. Why should we look into it? Tomorrow, that officer who has signed the affidavit, he may not be there in your company. Then,
no, my lord, his PTP has been filed by director of the company, my lord.
who is that?
My lord, yeah. Mr. More, my lord.
Huh?
Lordship,
So,
Nikhil's More, my lord.
so,
He's a director of the company, my lord.
it's-
My lord, there may be, my lord,
No.
some lapse in taking written instruction, my lord. But if this happen, my lord, if I may, I respectfully pray, my lord.
No
that
case.
this, my lord, it was in the final stage of hearing. Because suddenly it has come up, my lord. If your lordship,
You are making an allegation of against the judge. Yes.
my lord,
So, that has to be,
with
yes,
all due
that
respect, my
has
lord,
to be concrete.
with all due
That
respect.
tomorrow you are saying something that the lawyer, just for example, you take a case that the lawyer did not inform. And you file a condonation application before this court.
That I understand, my lord. That I understand. That I
This court will ask.
Definitely, my lord. That is the, my lord, but here, my lord, what has happened? The written statements that were argued, that were placed and urged, my lord, were regarding payment of gratuity. Some
Yes, government. Who is there for the government? Tell me one thing. How on earth a tea garden is allowed to be transferred like this? You are losing on the stamp duty.
That cannot be lost.
This is what is being happening. A tea company gives this to another one. Agreement for transfer of land and sale of the buildings and so and so. Transfer of tea land, can it be done in this manner?
No, Lord. That cannot.
Are there not specific notifications
Yes.
to that effect?
Yes.
Rights from 1991, when Mr. C.K. Das has
Lost.
done it.
Lost.
Then I think you should take a call on this.
Lost,
How
lost.
on earth this petitioner is running this garden?
Lost. We'll do lost.
Take an action against this.
We'll
Because
do
if this is there, tomorrow everybody will do
Lost.
this.
Lost.
Nobody will pay a single. This is how the transfer of tea garden will
Lost.
happen. You
Lost.
cannot allow this thing to happen.
Lost.
My lord, in the agreement, there is a specific
When
provision
that
for
particular
executing final deed of assignment, my lord. Pursuant to
Understood.
Permission.
But how can there be a transfer? How can there be a transfer on the basis of an agreement?
that cannot be lost. Even
Tell
that
me,
respondent number 7 loss is running.
you
so
are
it is
allowing
being
him
lost.
on a lease. It's a transfer without an NOC under 21A.
Lost.
How is it permissible? This is a case where serious action
Lost,
should
lost.
be taken by the government.
Will do.
We ask the government to take action, serious note on this, that if tea gardens are allowed to be sold in this manner,
Lost.
then the government is going to lose huge amount of
Lost,
stamp
lost.
duty.
Malum indicate
The land policy is also
lost.
there.
Lost.
It's a very serious thing.
Lost.
I think this should be taken out from you. If the garden goes, then the problem is solved.
It's a loss.
Then you don't need to pay even a tax or gratuity.
Lost.
My lord,
You don't need to pay gratuity also. Very good. The garden, let the state, if the APJ does not want to take it, initiate action under 300, the doctrine or sheet will come in. Take it over. There's no owner. Owner has given up his right. There cannot be a transfer otherwise by law. So apply doctrine of sheet, take over the garden by the state and put it along with ATC.
my lord, that particular provision of my lord is already in the agreement, my lord, of executing purchase. My lord.
Understood, purchased it, but how can there be a transfer of obligations? There cannot be a transfer of obligations on the basis of this agreement. There are requirements. You are violating the Plantation Labor Act on tooth and nail. Everything has been violated. You are given a go-by. This is not how you take a garden. It's a very serious thing which is happening out here. Therefore, I ask you the first question. Where is the sale deed? Normally, how is it done?
Sell it.
No. Gardens are not done through it. Normally, you sell it because of the fact that there is a big problem. You don't get a permission.
First, you have to
A tea
obtain.
garden being. The government does not grant a permission like this. The manner in which it is done is by way of demerger. You demerge out, take out these two gardens, this Ghoreali or whatever may be, take it out, form a company, take it out, and then merge it and give it to another company. This is how you do it. But this is not where that has to be recognized. That has to be, there has to be a stamp duty on that. People are losing. Government is losing huge. In
Two tea garden here.
and the government doesn't want. Two gardens.
Two tea garden here. Even Lordship, Response number 7 is running so many garden in Assam, Lordship.
And the laborers are suffering. Commerciaries are suffering.
Yes.
Why should we interfere?
Lordship.
Very bad case.
It will. We'll go for review then.
In the meantime, Lordship,
You look into that.
will.
Go for review. Make a judgment. ANZ Ginlech. 1983. It's the judgment of 1983. I have to give you something, then only you can go there, otherwise the people won't listen. See, you have, if you insist on these type of cases here now, and people like when it is before people like me who know how transfers are made in tea garden, you'll be in more deeper trouble. Don't do that. Never. For me. Give you that judgment how you. But Mr. Gogoi, I think the government, the labor department has to be brought into
Today itself I will communicate. Today itself.
It should be-
Today itself I will communicate.
These type of things keep on happening.
I'll.
Will have serious.
I should put agreement that will listen.
Yes, Greenledge Bank versus Central Government Industrial Tribunal. This is 1980 supplementary SCC 420. Okay.
No, sir.
and it has been recently affirmed by the Supreme Court in 2024 767. You see, this is also a case of industrial tribunal, where there was an ex parte order, certain orders were passed. There were no review permissible. Then the Supreme Court devised up a concept called procedural review. Here, your procedural review was without there being any document on record, admitted, just on the basis of verbal instruction, he could not. So there is a case of procedural review. Mr. G. Rahul, heard Mr. G. Rahul, the learned counsel appearing on behalf of the petitioner. Mr. K. Gogoi, the learned additional senior government advocate, appears on behalf of the respondent authorities.
1 to 4, Lordship.
Huh?
1, 2, 3, and 4, Lordship.
1, 2, 3, and 4.
Even Lordship, presiding officer was made party.
No, again,
They cannot, Lordship, as per the
goodness.
Honorable Apex Court judgment, Lordship. They cannot.
These are questions of which are seriously deprecated by the Supreme Court,
Lordship,
right,
Lordship.
left and center.
Even Lordship, last year also, Lordship.
I have also deprecated
Lordship.
many times. I think it is high time you deprecate the lawyer.
Lordship. That can.
Sorry, Mali.
The learned counsel appearing on behalf of the petitioner submits that taking into account the issue involved, whereby on account of a verbal submission which was contrary to a verbal submission of an counsel of the counsel, which was contrary to the records, the impugned award was passed. The petitioner would be well advised to approach the learned industrial tribunal in view of the judge taking into account the judgment of the Supreme Court in the case of Greenledge Bank Limited versus Central Government Industrial Tribunal, reported in AIR 1981 SC 606. He therefore submits that the petitioner may be permitted to withdraw the instant writ petition without prejudice to file the said review application. Taking into account the above, the instant writ petition stands closed. It is observed that the closing of the instant writ petition shall not prejudice the petitioner to raise such grievance in a proceedings of review if filed and falling within the ambit as observed by the Supreme Court in the case of Greenledge Banks Limited Super. Ask your client to be careful. Don't do all this.
It's 24, Lordship.
Yes.
An order was passed by the officer in charge of that unit. This laconic order was passed wherein the petitioner was ousted from the premises indefinitely. Till today, Lordship, we've issued 4 representations, but that has not even been considered. We received 2 replies. So, Lordship, after that, we issued a representation against this.
Who are you?
Lordship.
Or this
yes.
person. You
Yes.
have been asked to.
I'm the license holder. I'm the license holder of the unit, Lordship. The unit.
It's a bottling plant, Lordship.
So after that, Lordship, we issued a representation seeking justifiable since no reason was attributed.
Then,
Lordship, we naturally asked for the reason as to why such drastic step has been taken, because there seems to be no justifiable reason. After that, Lordship, the officer in charge also issued a reply. That reply, Lordship, will find at page 49. His reasonings, Lordship. Otherwise, Lordship, the tenor of the reply would otherwise reveal how desperate he was to oust the petitioner. Lordship, may I read the reply?
So FIR has been filed.
Not related to this, not related to anything concerned with this plan. It's a separate matter, not even been charge sheeted yet, Lordship. And indefinitely such notice has been passed.
Now what has happened?
Lordship,
Agreed by which document?
aggrieved by page 25, Lordship.
Page 25.
25. This notice was merely pasted on the unit.
This is being issued by whom?
This is the officer in charge of the unit.
Of this industry, it's a private industry.
Lordship, otherwise run by the government. The officer in charge, otherwise it's a statutory post under the Assam Excise Act. But he has invoked rule 489.
This was done on
2024, Lordship. In fact, we issued representation. They said they'll consider it also within a month or so. After that, they are sitting on it and enjoying it. Lordship, there's personal differences. In fact, such is the status that the office in which
A license has not been issued to you.
it is in my name, Lordship.
No.
License is annexed.
License is in name of this Siparu group of industry.
Yes, represented
by the partner. It has a difference out there. If the partner tomorrow changes, the license will also change.
Lordship.
Then
The Lordship, since last 1.5 years, I have not even been allowed to enter the premises.
who has not allowed you?
This, by way of this notice, Lordship, the officer in
number
charge
4.
is not even allowing me to enter the premises.
Is he an official of the government?
Yes.
Yes.
You are not allowing him.
Lordship.
Why?
There's some allegations against the petitioner is there, Lordship. He was arrested in some, in page 33, Lordship. There is some
Page
33, there is forwarding report, Lordship.
33.
Page 33, Lordship. Ground of arrest, Lordship.
What the accused person?
I am not even the prime accused, Lordship.
He's dear, Lordship. He was arrested, Lordship. His photograph is dear, Lordship, in the forwarding report, Lordship.
This happened on 25/4/2024.
Lordship.
And then you issued it on 35.
Yes,
30.
while I was behind bars. And in fact, after that, when he came up with the reply, he took reliance of the bail order, which was passed subsequently, Lordship. So otherwise, the tenor, this is not administrative, Lordship, this is vindictive. If your Lordship will kindly see his reply, the nature of his reply at page 49, how desperately he wants to keep me ousted from the premises.
Who?
The officer in charge, Lordship, who has issued this notice at first place. 49, if Lordship, I am allowed to read, it will
But
be.
you are a government official. Why you are doing action on behalf of them?
Lordship, there's a provisions, Lordship.
Huh?
There's a provisions in the excise rule, Lordship.
What do you say?
May I read, Lordship?
Please read.
The officer in charge of a warehouse may eject and exclude from the premises any persons whom he may find to have committed or to be about to commit any breach of these rules or of the provisions of the Excise Act, or who may be intoxicated or disorderly, Lordship. Here, some provisions is there, here's some power, Lordship.
But why you not cancelling the license?
Otherwise, that is prescribed under section 30 of the Act. So if that would have been the case, then it's different. But this officer in charge cannot sit on this notice, Lordship. I'm issuing.
I'm not siding one of the partners.
Otherwise, that person is by name a party, Lordship. That officer in charge, Lordship.
Therefore, I'm saying,
Lordship.
he is your employee.
Lordship.
Then why you have not taken any action? Why that officer in charge or even the commissioner of excise have not taken any action against the industry as it is? And this is being filed. Why haven't you make that company, the industry, the company as a party here?
Lordship, because personally I am aggrieved. Otherwise, the industry is running. Industry is running. The officer in charge with the other partners.
You continue to remain as a partner.
Yes, I continue to remain as the license. In fact, as the license holder also. As a license holder also, I continue to remain, Lordship.
No, you are not a license holder.
Yeah, I mean,
You are not a license holder. I'm asking you, are you still a partner?
I'm still the partner, Lordship.
So we made a registration of firm?
Lordship, that has not been annexed. But otherwise, I'm the partner, Lordship. That may be recorded.
Show me the last of the balance sheets it will show.
That is the issue, Lordship. Since last 1.5 years, my laptop, my iPad, everything is in the office. I'm asking that at least allow me to
But
take.
company is running,
Company is running,
but
Lordship.
the partnership firm is running.
Partnership firm is
Meaning
running.
thereby there is somebody who's running it.
Yes,
Who is running it?
Lordship, the other partners.
So therefore, why you are not making the other partner party out here?
Because Lordship, otherwise I'm aggrieved by the conduct of the officer in charge
He
himself.
must be doing it at the behest of those officials. Why will otherwise a person stop him and not take action against the license? Isn't it?
No, but Lordship, if your Lordship may kindly see the reasonings that he is himself relying on at page number 49. Just the end, how he wants me ousted, Lordship. If I may be allowed to read the entire reply. Lordship, due to your prolonged absence during your judicial custody, Lordship, can that be a ground?
No, I don't understand the last paragraph. Moreover, the aforesaid aforementioned order of the undersigned dated does not impinge upon the petitioner's right to livelihood or impinge or property and have no such intention to. Therefore, I am willing to rescind this order upon receipt of a no objection provided by the former in response to the consolidated charges against you. Who is the former?
So former happens to be, from what I'm understanding, Honorable CJM Court of Golaghat. But the facts are twisted. Charge sheet has not even been laid, Lordship, and I'm presumed to be complicit in that offense.
No, where
That
is
is
the
a-
former? Means I don't know, provided by the former in response to the consolidated charges against you.
If your Lordship will kindly see second paragraph, last line, he says, hence I do not possess the unilateral authority to revoke it without further guidance from the Honorable CJM Court.
And the consent, you see.
And the consent of the court
co-partners of so-and-so due to pre-investigation. Therefore, I'm saying, why haven't you make these people a part?
If required, Lordship, then I will make,
party.
but
Because this is one of the reasons. They are not coming forward. And it seems.
they are beneficiary of this. They are a beneficiary of this, Lordship.
Understood. They are not coming forward. The
In
reason is they are not coming forward to help you out. Means there is some dispute.
Yes, there is.
So
Lordship.
interstate dispute between you and him,
Lordship.
by which he is interfering,
Yes, Lordship.
is sought to be done. So don't you think that person is a party?
Otherwise, Lordship, on the face of it, the officer in charge should not be doing whatever he has been doing. After that, Lordship, I issued again a
So
representative.
therefore, how do I know whether that person is right or wrong? That industry.
But Lordship, on the face of
the industry being party.
Rightly so, Lordship, but on the face of it, the officer in charge, should he be posting such a laconic notice and then should he be sitting on such kind of notice? All I'm asking is, Lordship, there is an office inside the premises, which I used to be presiding in. My laptop, all my ID proofs, entire thing is there since 1 year. I have even requested him that you escort me to the office. Let me take belongings of that. He is not even allowing that since last 1 year, Lordship. So this is not administrative otherwise. This is purely vindictive. And I'm being, in fact, my house is adjacent to the plot. I own the plot itself. I am also not getting the proceeds or the profits. Otherwise, I was receiving that in my bank accounts. Since last 1.5 years, I am not even receiving that. Financially,
Therefore, the question is, who is not giving you the profits?
That is, Lordship, for that I'll file a commercial suit. Probably that is going on. He is already taking care of that. But so far as the action of the officer in charge is concerned, who is otherwise a statutory authority.
But you have to allege that he is doing at his whose behest.
Lordship, that otherwise would be speculative from my end also. On the face of it, I am just challenging the notice. That such kind of notice,
We issue a
and
notice only.
Lordship, if one thing maybe one
No, only
relief,
notice only. You are challenging the notice, we'll issue notice.
Lordship. Otherwise,
Let it go on for years to come. Issue notice making it returnable on 15th of December 2025. Mr. N. Gusami appears on behalf, accepts notice on behalf of the respondent numbers 1, 2, and 3. As regards the respondent number 4, the petitioner is directed to take steps by way of registered as well as usual. The case of the petitioner herein is that the petitioner is a partner of a firm in the name and style of MS Sifaru Group of Industries, who have been issued the license for bonded warehouse of Indian-made foreign liquor. In the said license which have been issued, the said firm have been shown as, in the name of the licensee has been shown as MS Sifaru Group of Industries, represented by the petitioner. The record revealed that in consequence to an FIR being filed, registered as Gulagat PS case number 0075/2024, the petitioner was arrested on 24/4/2024. 25/4, arrested on 24/4/2024, and thereupon produced before the learned CGM Golaghat on 25/4/2024. On the basis of the arrest, which was in connection with offences falling under sections 120B, 328, 3336, 418, and 420 of the Indian Penal Code 1860, read with section 53 Roman 1, 53 bracket capital normal 1, numerical 1, bracket small a, small b, small c, small d, small e of the Assam, what is this?
Excise Act.
AP, what is this? AP Excise Act?
Okay.
And the AP Excise Act. What is AP Excise Act 1968? Can't be AP Excise Act, it was
Excise Act
2020, isn't it?
2000. Assam Excise Act.
Assam Excise Act 2020. 2000.
Yes, 2000, Lord.
2000. The respondent number 4, who is the officer in charge of the respondent, officer in charge appointed by the Excise Department of the Government of Assam, in the bonded warehouse belonging to the petitioner, or in the bonded warehouse of MS Sifaru Group of Industries, had issued a notice dated 30/5/2024, thereby not permitting the petitioner access to the manufacturing premises The grievance of the petitioner herein is that the respondent number 4, out of malice, have not permitted the petitioner to access the manufacturing unit. And this aspect of the matter is very clear from the order dated, from the communication dated 20/11/2024, whereby the petitioner was informed that he would not be permitted to, that informed by the respondent number 4 that he would not he would not rescind the order dated 30/5/2024 for reasons other than bona fide. The learned counsel appearing on behalf of the petitioner submits that the respondent number 4, being an officer appointed by the excise department, his duty is only to look into as regards the provisions of the Assam Excise, as regards compliance to the provisions of the Assam Excise Act 2020, as well as the rules framed therein under. The learned counsel for the petitioner submits that the respondent number 4 cannot intermeddle with the disputes, with any dispute between the petitioner as a partner with any other having no relation to the Assam Excise Act, to the provisions of the Assam Excise Act 2000, as well as the rules framed therein under. The respondents herein are directed to bring on record their affidavits. They stand by filing an affidavit on or before 1st of December 2025. Liberty given to the petitioner to file reply thereagainst.
13.
What, non-payment?
No, Lordship. This is a tender matter, Lordship.
In was floated from Iman that inviting tender. Yes.
Malak, may kindly come to page.
Where is the clause number 5?
Lordship, page number 30. Page number 30, 30.
30.
30, Lordship. Clause number 18.
Clause number?
18. This is in
Where
the
is it?
tender notice itself. 18 and 19. Now, my lord, may kindly come to page number 51, that is executive instruction, clause number 5, 4 and 5.
Now where is that comparative statement?
Page number 46, my lord.
Number?
Page number 46.
42.
46. 46. Column number 10.
Who is the respondent number 8? What is the name?
Page number 47 at serial number 8. Mohibul Haq.
Police report.
Column number 10.
How do I know? 1, 2, 3, 5. 10. No.
It's no.
Police report is no.
And my name is there, Lordship, at serial number 9.
And
Immediately
your
after.
name is?
Abdul Salam Pradhani.
What is your name?
Abdul Salam Pradhani,
Ah,
serial
yes.
number 9.
So you are the only, and another one, Brother Bolo. Brother Bolo has put 3,88,000. Why that is not being given?
As because Lordship, the executive instruction, Lordship may kindly come to page number 51 once again.
More than 10%.
More than 10%, Lordship. Clause number 1. Page number 51, clause number 1.
Should not exceed 10%
Yes, Lordship.
of the average of the
Average of last 3 years.
last. And what was the last 3 years? Have you given it?
No,
Counselor?
Lordship, I have not given it, Lordship, but so far my instruction is concerned that that is the bid, Lordship, the other person has submitted.
That is not an issue involved.
Yes.
Yes, Mr. Toto, how is it that you are not?
My lord, as per the petition, my lord, the impugn order, my lord,
Page number 50.
Page number
50.
50.
Ah.
And this was, my lord, as per the resolution of the settlement committee, my lord. So settlement committee headed by the president is the accepting authority, my lord, and this resolution was not annexed with the petition. Therefore, at this stage, my lord, I am praying for records maybe call for, my lord, and thereafter interim may be considered, my lord.
Stay.
My lord, one more that I want to show one more thing, my lord. The comparative statement, my lord, as 46 and 47.
Yes.
The first 46, my lord. My lord, there is a self affidavit is required as per clause 12. That was not submitted by the any bidder, my lord. That was also a mandatory condition.
Yeah. You can cancel it.
Yes, that is why, my lord, I
So
want
therefore, we stay.
I leave it to lordship. But as per 1055 may be directed, my lord,
That is your lookout.
because
You know what to do.
otherwise they will do differently, maybe, my lord.
1055. Yes.
Department can run directly.
Issue notice making it returnable after vacations. Sir,
Yes.
there are a lot of people outside.
Yes, my lord.
Issue notice making it returnable on 15th of October 2025. Mr. S. Dutta accepts notice on behalf of the respondent number
1, 3, 5, and 7.
5,
And 7.
7.
Official response.
Ms. Udas accept notice on behalf of the respondent number 2. Extra copies of the petition be served upon them during the course of the day. As regards to respondent number 4, 7, and 8. 4, 6, 7, and 8.
7 I am appearing, my lord.
Oh, huh?
7 I am appearing.
4, 6, and 8. The petitioner are directed to take steps by way of registered as well as usual. In addition to that, petitioner is directed to take steps by way of speed post as well as usual. In addition to that, the petitioner is also directed to effect service upon the respondents. The respondent number 6, respondent number 4, 6, and 8 by way of trustee routed to the registry of this court and file an affidavit of service on or before the next day. The petitioner herein, along with various other bidders, participated in pursuance to a tender notice dated 2/6/2025 for settlement of Udorhat Dharamsala Hat the grievance of the petitioner herein is that though the petitioner had quoted the same rate with that of the respondent number 8, but the respondent number 8 was granted the settlement in terms with the order passed by the secretary, Dharmasala Gaon Panchayat, dated 30/8/2025. The learned counsel, appearing on behalf of the petitioner, submits, drawing the attention of this court to the comparative statement, submits that a perusal of the said comparative statement would show that the petition respondent number 8 did not submit the police verification report, which is required in terms with clause 18 of the tender notice, of the terms and conditions of the tender notice, and as well as the executive order dated 21/5/2025, issued by the additional chief secretary to the 25/2025, issued by the additional chief secretary to the government of Assam Panchayat and Rural Development Department. The learned counsel, referring to the said executive order, and more particularly to serial number 4 and 5, submits that it is essential that there has to be a police verification report submitted along with the bid, and the same having not been submitted, admittedly, having not been submitted in the case of the respondent number 8, or all other bidders except the petitioner. All other bidders were disqualified, and the settlement ought to have been granted in favor of the petitioner. The learned counsel, appearing on behalf of the petitioner, further submits that the respondent authorities, in order to favor the respondent number 8, have given a clear go-by to the tender condition as well as the executive order, and as such, it is a fit case wherein interim directions are required to be passed. Mr. S. Dutta, the learned counsel, appearing, learned standing counsel of the PNRD, submits that it appears from the comparative statement that the respondent number 8 did not comply with clause number 18, as well as the requirement of clause 4 and 5 of the executive order. He further submitted that there is a requirement of a self-declaration affidavit to be filed, which from the comparative statement would also show that the same have not been furnished by any of the bidders. This court having given, he further submits that what was the further consideration of the respondent authorities to grant the tender in favor, grant the settlement in favor of the respondent 8 can only be asserted after obtaining the necessary instructions. This court have duly considered as to whether there is a requirement of passing any interim directions in the facts, as in the facts and circumstances of the case, as is apparent from the writ petition as well as the submissions so made by the learned counsel for the parties. It is the opinion of this court that it prima facie appears that the respondent number 8 was granted the settlement by the impugned order dated 30/8/2025 in violation of clause 18 of the tender notice, tender conditions, as well as clause 4 and 5 of the executive order. Under such circumstances, it is therefore the opinion of this court that the petitioner is entitled to certain interim directions. Accordingly, this court observes, this court passes the following interim directions. Number one, the executive order, the impugn order dated 30/8/2025 issued by the Secretary, Dharmasala, Gram Panchayat, in favor of the respondent number 8 pertaining to the lease for Hadurghat Dharmasala Doinik Bazar, Dharmasala, shall remain state till the next date. Number two, this court further takes note of that this particular daily bazaar has to run in the meantime. Accordingly, permits the respondent authorities to exercise the powers under section 105(5) of the Assam Panchayat Act 1994 as amended up to date to take appropriate steps till the next day.
Record may be called for. Record may be called.
Supplementary item 48.
The records, the respondents are directed to bring on record their stand by filing their affidavits on or before 13th of October 2025. The records, further to that, taking into account that this court had passed certain interim directions, it is be essential that the matter is resolved at the earliest. Considering the above, an attempt shall be made to dispose of the petition on the next day. And the respondent, respondent authority, the council appearing on behalf of the respondent authority shall ensure that the records of the settlement of the bazaar in question is produced on the next day.
Highly applies.
Yes, what it is?
My lord. In this case, my lord, I have I have been successful in bidding.
Huh?
I have been successful in bidder, and accordingly, letter of acceptance was issued to me. Letter of acceptance issued to me. Thereafter, what happened, my lord? I have been asked to submit performance guarantee by bank guarantee. I had submitted to extension of time. According to conditions of contract, I can submit the performance guarantee within 60 days. So I taken action. Thereafter, I have submitted performance guarantee. But later on, what happened? They have issued me a letter that your performance guarantee is not in the name of the company which had made the bid. What happened, Your Honor? Previously, my name was RV Engineering Consultant Private Limited.
The name was RV Engineering Consultants Private Limited.
That name was, it is RV Associates, sorry, RV Associates Architects, Engineers and Consultants Private Limited. That was my name. Later on, we have changed the name of the company. So during pendency of the bid.
During the pendency of
bid. After submission of bid, we have changed the name of the company.
What was the name earlier?
Earlier name is RB Associates Architects, Engineers and Consultants Private Limited. So the name.
So you submitted the bid in the name of RB Associates Architects, Engineers Private Limited in consortium with Prabhavi.
Then we have changed the name. In the meantime, before issuance of LOA, we have changed our name. Accordingly, it was updated in the railway site, railway procurement site, as well as we have also informed to the railway also. By letter dated 5/5, we have informed the railway that we have already changed the name.
5/5, is the page?
That is some. Well, I'm still learning. My lord, that is 5/5/25. Page 82, my lord. Before issuance of LOA.
When was the letter of intent issued?
My lord, that has been issued on 4/6/25.
Before that, you informed.
We informed, my lord. Not only that, my lord, not only that.
Intimation of the name change post conversion from private limited to limited.
Well.
Then
Not only that, my lord, but in the next page, my lord, Annexure 15, my lord. Annexure 15, my lord. Page 83.
Yes.
They have called us for negotiations by the new name. RB Engineers Consolidated Limited. They have called us for negotiations with the new name.
You have to submit your revised bid online before closing.
My lord. So they have.
So you submitted your revised bid.
My lord, revised bid for some other matters, my lord, that has been submitted accordingly after negotiations. That bid had been accepted, my lord.
So this has been issued to RB Engineering Consultants Limited.
My lord.
That is the petitioner here.
My lord. This is right now, my lord.
Earlier it was some architects.
My lord.
Now it is issued to RB Engineering Consultants Limited.
So they know the change of name. They know the change of name.
Now
Particularly, my lord, in LOM also, my lord, in the page 22, in LOM, my lord, page 22, my lord. Page 22, my lord.
Now this is the termination notice.
In LOA also, my lord, they have mentioned my new name.
What is the LOA?
My lord, at page 22, my lord, LOA.
22.
Firstly, they have written RB Associate in old name.
This is being given to that
RB old name. Although they know,
the architects one.
All they know that they must changed. Because they have called us prior to issuance of LOA, they have called us by the new name.
Now
then,
where is your bank guarantee?
Then, my lord, letter of acceptance, my lord.
Where is your bank guarantee?
My lord, another thing I would like to point out, my lord. Another thing I would like to point out, my lord. In this LOA, reference number 2, your bid ID such and such submitted by RB Engineering Consultant Limited, new name. Again, in the LOA, my lord. It's reference. Subject letter of acceptance, reference number 1, number 2.
Your bid number is submitted by RB. Okay.
Here they have mentioned. So they know that the company is same. They know that company is same. Then we have submitted the BG bond, my lord. BG bond is submitted, and bank guarantee bond also says that.
Where is the bank guarantee?
My lord. It is page number page 28, my lord. And bank guarantee starts from page number 29. Bank guarantee page 29, my lord. Bank guarantee issued on behalf of Messrs. RB Engineering Consultant Limited, formerly RB Associates Architects Engineering Associates Private Limited. It is also mentioned clearly. Both my names are given, my dear.
So this is your bank guarantee is in the name of the petitioner.
In the
Isn't it?
Yeah.
Now let's see.
They have mentioned both the names. My previous name also mentioned here.
Now let us see your
My lord, thereafter what I have done, along with
where is your termination?
my lord, before termination, they have asked me to change the bank guarantee in the name of old concern. The termination letter is page number 84, my lord. Page 84, my lord. In the instead, you have failed to submit PG in the name of selected bidder, that is Messrs. RB Associates Architects and Consultants Limited in consortium with Prabhavi, in spite of office letter of request to PG with 5 reminders as referred above. This has been considered as non-compliance of clause number 66. That is not correct. We have submitted the bank guarantee within limitation period.
Yes, Mr. Gogoi.
So Lordship, firstly, I clarify the Lordship LOA part Lordship, which petitioner have indicated. So my lord may kindly come to page 22 Lordship.
22.
22.
Yes.
LOAs issued Lordship in respect of Lordship Messrs. RB Associate Architect Engineering and Consultants Private Limited Consortium with Lordship RB Lordship. This is the Lordship bidder Lordship. Then Lordship he has indicated serial number 2, where he has indicated that his company's name was new company's name was reflected. So my lord may kindly come to 2.2 Lordship.
2 point?
Only 2 Lordship. Reference number 2 Lordship. Your ID dated so and so dated 05/11/2024. My lord may kindly mark it. 05/11/2024. It is on 2:15 p.m. Lordship. Submitted by MSRB Engineering Consultant Limited, Hyderabad. This is the reference when uploading the Lordship that bid document Lordship. It is on 5/11/2024 Lordship. Bid document was uploaded in the name of Lordship RB Associate Architect Engineering Consultant Private Limited Consortium with Parby Lordship. So my lord may that company's name was changes. So my lord may kindly come to page 40 when changes was done Lordship. Page 40 Lordship.
The change have happened page 82A.
Page 40 also Lordship. Page 40 Lordship. Page 40 Lordship. It's issued by the Minister of Corporate Affairs Lordship. First paragraph, last 2 lines Lordship. 04/02/2025 Lordship.
It is given on 6th day of Iman, where?
It is on Lordship 6/2/25 Lordship. And with effect from Lordship 4/2/25 Lordship. So Lordship, when bid was uploaded, that company was not there. Bid was uploaded on Lordship 5/11/2024
Now,
Lordship.
what do you say about this particular document?
Which one Lordship?
Which negotiation took place? There's one document which I saw, which whereby negotiations took place.
That page 83 Lordship.
Page 83.
Page 83 Lordship, by way of that particular document, the terms and condition of that Lordship NIT cannot be changed Lordship.
The competent authority has accorded approval to the conduct one round of negotiation
Lordship.
with you to explore of reduction in rate. You are requested to come for negotiation on so and so 11 hours at the office of the so and so to negotiate the offer value of the H1 bidder. Please depute the remand filling so and so.
That particular document Lordship cannot be changed the condition of the Lordship NIT Lordship.
Negotiation authorization. You will have to submit your revised bid online before closing date on.
So my lord may kindly come to the condition part Lordship. Then Lordship page 83 Lordship. Original office against tender shall remain open for acceptance of on its original terms and conditions Lordship.
Oh, you have rejected on the ground that the performance guarantee was not in terms with the
Lordship,
bid.
bid lordship. So lordship,
Now, the question is,
lordship,
if the performance guarantee is given
lordship.
in respect to a company which no longer is there, how do you work out? Just for example, tomorrow,
Lordship,
you give him a chance and he gives it.
lordship.
But how do you invoke the performance guarantee then?
That part is otherwise lordship. Before changing that lordship in the during that substitution of the contract lordship. Before changing, they have to inform the authority lordship. Before changing, that clause is here lordship. I'll place one by one lordship. Even if lordship permit, I can place at this moment also. Otherwise, there is arbitration clause is there. It is covered by my lord judgment. Exactly same footing lordship.
No, Mr. Sharma, there is one big issue.
My lord,
The bigger issue is, what about the PG? Another aspect is there in the termination order. You submitted your bid as initially as that RB architect and so in consortium with Prabhat. Prabhavi. Then later on, it is seen that it is only submitted as the petitioner company,
my lord,
nothing to do with Prabhavi.
my lord, that is my lord. Actually, according to contract, the
Because
lead
it's a
lead
joint-
partner, the lead partner will have to do
because
all the things.
you have applied as a consortium.
Consortium.
You
Consortium.
have applied. The tender was as per the consortium.
Consortium, my lord.
Take care of that.
My lord.
Lordship.
Because you see, what is at page 85, if you see,
Mhm.
the date of issue of the LOI, along with interest from the date of LOI, with interest after the grant of area. Besides, the intimation of the change of the name was not accompanied with a modified joint bidding agreement to establish the changed name of the bidder.
My lord, here, my lord, they are not disputing, they are not.
No, but he's not a party.
No, they are not raising any dispute that I have submitted in my name. Their dispute is that.
You see,
My lord.
Mr. Sharma, the problem arises is this. It is a contract, it's a joint agreement, it was a joint bid,
My lord.
isn't it?
My lord.
If it is a joint bid submitted, isn't it required that the consortium partner should be a party in the proceeding?
In fact, my lord.
It means
My
to
lord.
join you.
My lord. My lord. In fact, I am the lead member.
Understood.
I am the lead member.
Then
And
also-
so, according to clause of contract, lead member is authorized to do all the things.
Absolutely. But then
According to
also that
contract, my lord.
person is there, na?
According to contract,
How to
members of
take
the
care of
consortium
that?
shall nominate one member as the lead member. My lord, it is paid 101, my lord. Paid 101.
They are going to go ahead with a fresh contract. Tender.
Even lordship 102 page 102. My lord, may kindly press for a moment lordship. 102 lordship page 102.
Yes.
Roman 8 lordship. Before the Roman 7 is 7C
No
is also
change in
there.
composition of the consortium will be submitted to the authority during the selection process and during the subsistence of the project.
Even lordship 7C also lordship. Now they cannot lordship.
Where is the arbitration clause?
Arbitration clause they have not annexed, otherwise it is there lordship. My lord. It is there. Dada.
Mr. Sharma,
Correct.
My lord.
are you in good terms with that person? Your joint bidder,
My lord.
are you in good terms?
Yes, sir.
Lordship, even I have
Good
received
terms, my
the,
lord. They have given the authority.
even I have
Our-
received the instruction
our
also in that
relative is
particular
notified.
matter, Lordship.
It's okay.
Lordship.
This we'll look at it later on.
Lordship.
Mr. Sharma, why don't you withdraw and file a fresh one, making him also a petition?
My lord, we are our petition, my lord, but kindly say our petition, my lord, with Prabhavi, along with Prabhavi.
You see, unless
My lord,
you see,
are we injuring
Mr.
consultant
Mr.
limited?
Sharma, you are not understanding. There is a judgment passed by me already on this issue.
My lord,
This matter judgment has also been affirmed by the division bench.
my lord,
Matter went to Supreme Court also dismissed. Now, when it is a filed by a consortium, the second party, the party has to be a party.
my lord, my lord, my
Why
lord,
you are not making him?
my lord. Company.
If you insist, then on that point only I can dismiss your petition without going further. I give you before the opportunity.
No, look,
Make him a party.
my lord, may kindly, my lord, may kindly one, my lord, petitioner, are we injuring consulate private limited in consortium with Prabhavi? In consortium with Prabhavi, represented by Ram Madhira. And now, my lord, authority letter has been given by both. My lord, both has applied, my lord. It is annexure number A, 1A is the authority letter given by Prabhavi.
Annexure?
Annexure 1A. Page number 21A. Authorized to lead member for legal proceeding. My lord. And he authorizes to.
Okay. So here you are.
Well, in cost title also I've mentioned with
Then why
Prabhavi.
don't you file an IA?
With Prabhavi.
Why don't you file an IA and make him a party?
My
We'll
lord.
take it up on Friday.
My lord, that will be done.
Because of this, and he has been authorized, he has been assigned and filed as IA before the Honorable High Court. So this permission is already given.
My lord, my lord.
So make him a party.
My lord.
Then this is regularized.
My lord. Otherwise also we have although we have mentioned his as a consortium we have made a party. RV Engineering Consultant Limited in consortium with Prabhavi. My lord. We have named our company's name is there. That's in consortium with Prabhavi.
Huh?
RV,
No, here it is not there, na.
RB Engineering and Consultant, formerly known as RB Associates, a company under companies
In the name of party.
in consortium with Prabhavi. My lord, our name was in consortium with Prabhavi. My lord, we have submitted tender also as in consortium. That is a consortium, my lord. You will not know that a consortium, just like a joint venture, just like a joint venture.
Yes, I understand.
Now it cannot be lost.
These are
Therefore, make him. In fact, you wanted. You have put one. When you have petitioner, one petitioner, you don't want to put one.
You made them one party.
You
With Prabhavi, a one party.
You make a two.
That is.
Let us have it on Friday. You file that small I because you have been authorized. That person can very well file this petition. Then this problem is solved for that. Now the question is because then you get the support. This takes care of your that problem which is there in page 85 clause 4 order.
My lord,
that is being taken care of if you make him a party.
My lord.
In the you are challenging the termination notice.
My lord, my lord.
In the termination notice, there is two grounds. One is that RV has come alone and not as a joint venture. Last line.
My lord, actually, they want to say that I have not filed a fresh agreement with RV with this with Prabhavi.
So therefore, get the support in your petition through this aspect. So thereby the problem in clause 4 is solved.
Regarding my lord,
Mr. Sharma, I hope you have understood.
Yeah, my lord, I understood. Only I want. We'll
have it on Friday.
Friday we can.
You file your IA tomorrow. We make him a party immediately, then we can proceed. Don't you
My
think
lord,
so?
only one thing, my lord, I would like to clarify, my lord. Only one thing I would like to clarify that.
Reply on Friday, we can have it.
I lord, I wish Friday. But till then, well, at least till then they should not proceed for appointment of further appointment. Otherwise,
You submitted the tender on 15/11/2024. And they gave it to you on
on my lord.
May 2025.
I don't know, my lord.
7 months, na?
My lord.
I'm only asking you time till Friday. It's the matter again Friday. In the meantime, you file that. I'm not indicating, but you file it. This is the matter on so and so at 2 p.m. I'm putting it at 2 p.m. because the moment you file it, it will otherwise come up in orders. So we'll take it up at 2 p.m.
Last night.
2 p.m.
Motion stays only. Yes.
What do you have? Directly, this application to file that to produce the records.
Your issue is small.
This is so common.
On the question as to whether they were right in holding that you did not have the qualification, taking into account that clause 5. Clause 5.
Clause 5 at page 29, madam. Past performance.
There are two grounds. One is on that, and the second is when there is only one single bidder.
One single bidder. For the rule 20.
That there is a
23,
requirement
20.
to know as to what steps are required.
What the steps are to be taken, how this it is justified, madam.
There is no.
When there is a
only
lack
one.
of competition,
Huh?
when there is a lack of competition, only single bidder, how the process should be done, under the procedure had to be followed, the justification had to be down to me.
It is given in those rules, na, that procurement act, isn't as the procurement act. That's what? Procurement. Yes, what do you have to argue? I'm procurement.
Lordship, I am appearing for the private respondent number 5. The tender was awarded in my favor.
You are the single.
I'm the single.
Now
Subsequent to
here he
technical,
says
Lordship.
that, look here, as regards 5 stipulates. Rules says that as regards this, supplied category for 80% of the bid quantity, at least one of the last 3 financial years before the date bid opening to any central government, so and so and so and to be submitted along with the bid in support of the quantity supplied in the relevant financial. In case of bunch bid, the category related to primary product having the highest bid value should meet the criteria. How do you say that he is not qualified as per 5 in view of the documents which he have referred?
Lordship, admittedly, he had not submitted the required documents within time.
Huh?
He had admittedly not submitted documents within time.
He did not submit?
No, Lordship. I'll take your Lordship first to page 218, Annexure 10 of the writ petition, Lordship.
Yes.
Lordship, it is a true type copy. Lordship may see on page 217, on the left-hand side, the narration down below. This is submitted by the petitioner subsequent to his rejection. First, on the top, your Lordship is seeing date
When
and
was
time.
which is the last date for submission?
Last date for submission was, Lordship,
Four three 25.
Huh?
4/3/25.
4/3/25 on page 26, Lordship.
2025.
5.
8,
26, Annexure 5.
26. Okay, then once
Then-
he came to know that
First-
it has been rejected, then he submitted this document.
Then he submitted the OEM certification of that Bihar state government. No,
On 26/7.
on 26/7. 26/3. On 26/3 he submitted.
26/3.
Yes.
That is page 218,
218.
219.
That is the document, my lord, along with that particular mail, my lord, it was furnished.
Yes.
In the next page, also you will find that particular certificate, experience certificate.
If your Lordship see it, page 218, undertaking submitted by the petitioner.
Yeah.
That were missed under seen the clause 5 of the bid document.
Hmm.
And so we are now
It
submitting
was done on 25/3. 25/3.
25.
Finally see on top.
Yes, 25/3.
That on top 309. 25/3/2025.
Yes. And it was rejected 26/3.
Rejected prior to that?
No, after the presentation.
No, his rejection was earlier.
First rejection was earlier. Your Lordship may come to page 217. The narration is given. Page 217. Disqualified status, that is of 19/3/2025. Page 217 on the.
So it was
top.
rejected on 19/3.
Yes, Lordship. The
Disqualified.
comment is no single work completion certificate submitted amounting to rupees 1.26 crores. That is as per requirement of additional terms and conditions clause 1.1.
Failing to demonstrate which was mandatory as per IMAR. No single order certificate submitted amounting to 1.26 crore. Because what is 1.26 crores? What is the reason why?
Basically, bid valuation is 2 crores 53 lakhs.
Okay,
So
80%.
50% has to be his single work completion as per additional terms and conditions clause 1.1 on page 77. Clause 1.1, Roman 2, should have experience of similar nature of work, at least 50% of the value of tender in a single contract work order.
This is in correlation with clause 5.
Clause 5. But clause 5 document of OEM was not submitted by him before this last date of technical bid.
So this he submitted later on.
Later on.
Yeah, okay. This
So now he's
submitted
claiming
later
that
and
OEM was not considered.
So here they have experience of similar work. So it is not the OEM.
Not the OEM.
Page 77 is not the OEM.
That is for himself, the petitioner himself.
So he did not submit this document.
He submitted, but he did not submit any work order of single work order of 50% value. That is 1.26 crores. For which his technical
Single
bid was
contract.
rejected.
Single contract.
Yes, Lordship. Then subsequent to rejection, now he came up submitting the certificate of his OEM, which was as per clause 5. So on page
This
one,
was submitted
later on, much after rejection,
25/3.
25. His rejection was done on 19/3.
So the problem with him is non-compliance with clause 5 of the tender condition.
Yes, 5 and additional terms 1.1. So having been not complied technically at the initial stage, he cannot take grounds at a later stage on being disqualified. And the second point that he is a startup was not considered. It was very much declared that startups will not get any benefit. Lordship may turn to page 27, which is a tender condition. In the table around middle, Lordship will find startup exemption for years of experience and turnover, no.
No.
So he was aware that there is no exemption for startups.
So here is anything else? What do you say about the procurement?
Supplement to what my understand is saying. These are factually correct. He has submitted this OEM's experience certificate after the last date of submission of bid. Which
No,
cannot
he
be-
submitted on 25.
Yes, the last date was 4/3/2025. It is
He
at page
submitted on
26.
25/3.
Yes. And Lordship will see page 20.
Rejected on 19/3.
Yes. Now Lordship will see page 28 regarding EMD exemption. EMD exemption,
What
page 28, after the chart melody A, EMD exemption. The bidder seeking EMD exemption must submit the valid supporting document for the relevant category as per JAM so and so with the bid. Under MSME category, he has not opted for this melody. And instead, he has submitted the EMD. I have a copy of that melody. Earnest money deposit, this is the earnest money deposit that was submitted.
He submitted.
He submitted. He waived his own right to claim exemption under this MSME or startup. And otherwise also startup and MSME benefit can be given provided he supplies his own product. Here he is working as an agent of that OEM. In fact, this particular document, annex page 24, or you will see for a moment, his own document, annexure 4, page 24.
Yes.
That second para, the following exemptions under GRF, that is General Financial Rules, may be useful to be used for procuring innovative products created by startups. It will have to be an innovative product. You will have to supply his own product. Not working as an agent of a particular OEM. Here he has only submitted the bid on behalf of Durian Furnitures.
What he is saying, I have put even in the mail said later on this bids have been submitted mailer. But we'll come to page number 88. 88.
Yeah.
These are the check slips, my lord. All these documents have been submitted on the top, my lord, 4/3/2025, including the OEM. Entire OEM part, my lord, it starts from page number 140 onwards, my lord.
Where?
Page 140, my lord. OEM's part also, along with the bid, it was submitted, my lord, along with the experience certificate, as well as the certificate of turnover, page number 147 and 148. This is the 147 is the turnover of the OEM, and other is the experience certificate of the 148 is the experience certificate of the OEM. That is supplied to the Bihar.
So you say that these
are part of
documents you
the
have submitted.
And on last date of the day 4/3/25, it is submitted along with all these things. First is the experience of the petitioner as well as the OEM. The records will make it clear, my lord.
These are part of the document. Only thing is that in a mail, it is resubmitted. That you see that in page number, in clause number 5, there is a, as per clause number 5, all these things have been submitted. And
But what do you say about the additional terms and conditions?
additional terms and condition, but it only supplements the main terms and condition, my lord.
No. Additional terms and conditions, you have to follow 50%.
Additional,
Unless you challenge the additional terms and conditions.
there is a additional terms and condition, but clause 5 covers my entire.
Understood, but that is a part of the additional terms and conditions, is a part of it. Therefore, they did not reject on the clause 5. It appears. It appears they did not reject on clause 5.
The rejection is on the part that you don't have a 1.26 crore.
That is in terms with additional clause 1.1.
That is not made clear, my lord. Additional with lot will turn to the rejection part, my lord. Again, my lord.
Page 77.
Page
Rejection is 218.
217 is the original, my lord.
Okay. Failing in the
But
demonstration,
disqualification-
which is mandatory as per bid content, no single work completion certificate submitted to 1.26 crores.
No single work submitted. Not, it is not made it clear, my lord, whether the participant or the OEM, my lord.
No, here the OEM does not arise as per 77 clause, page 77.
Page 77 is the additional clause, my lord. But there is a additional clause is there, but it cannot supplement the clause 5, my lord. Clause 5 is the main clause, which the tender has fulfilled, my lord.
You know, this court has a lot of problems in accepting this type of argument.
And this is the technical bit, my lord. In the checklist, he has even designated it.
Yes.
And within that designation, my lord, portion, this, my lord, experience of the OEM is not there. This is the document. If we can show from his writ petition as well as his record. Checklist, my lord, it has not been mentioned.
Bidders pen, bidders firm registration, bidders GST, bidders so and so undertaking for warranty declaration for affidavit for non-blacklisted availability of escalation, malicious code, bank solvency survey, ATC certificate, bidders declaration on not being, bidders MSME registration, bidders startup registration, data sheet of the products partnership. Not there.
And my lord, this is the minutes, my lord. Very clear, my lord. The additional terms and conditions has not been fulfilled. These are minutes of the, my lord, tender comment. I have the original, my lord, this photocopy. Serial number 2.
So no single work complete
Yes.
certificate of bidder having 1.26. Hello, I think the
When in the rule, my lord, 23(2), that had to be followed while giving the other side, my lord. That has not been followed.
That particular document, the first document I submitted, that his complaint, my lord, that representation. Lordship, may I read it, my lord? It says, my lord, with due respect, we are sorry to say that we underseen the clause 5 in the bid document saying so and so. We now upload the relevant documents. Now upload, this is their language, man. No, the first page. Representation, challenge, description. This is the representation of the petitioner.
It's submitted in the uploaded document that been put in.
We now upload.
Which document you are referring?
Well, this,
Which one?
yes, my lord. First portion, my lord.
With due respect, we are
Yes,
sorry
yes.
to say that we have underseen, missed out clause 5.
Then lordship will see, my lord, we now submit.
Which are the documents, my lord? The document number 227, 20.
Mr. Gugoi give it to you.
I don't give it.
Let us have a fair fight.
Lordship.
No, that I have typed it, my lord. That is the part of the record. I have typed it, my lord.
Understood. With
Yes.
due respect, we are sorry to say we have underseen missed out clause 5. This is the most important.
My lord, they have seen that.
Chalo. Heard Mr. S. Bora, the learned counsel, appearing on behalf of the petitioner. Mr. B. Gogoi, appear, the learned petitioner, Advocate General, appears on behalf of the respondent numbers 1 to 4.
My lord.
1 to 4. Mr. Dr. A to T appears on behalf of the respondent number 5. First, the petitioner herein is aggrieved by the actions on the part of the respondent authorities in disqualifying the petitioner in respect to a tender for supply of various tender for supply of what is this supply of interior furnishing works of for supply of
Various articles, my lord, page 26.
various
my lord.
articles for supplying of goods in respect to interior furnishing works of Dhakuakana Circuit House. By information given to the petitioner on 19/3/2025. The materials on record show next that a tender, an e-tender was floated by the GM under the aegis of the GM, E to Hulu. Bearing bid document number GM/2025/B/5927802, dated 10/2/2025. For supplying of various goods required in connection with the interior furnishing works of Dhakuakana Circuit House. The item categories were duly mentioned in the said bid document. It further appears that the last date for submission of bid was on 4/3/2025 at 1300 hours, and the bid opening day was on 4/3/2025 at 1330 hours. Taking into account the dispute which have been raised, it is pertinent to take note of that in the said bid document, it was categorically mentioned in the column, inverted comma, startup exemption for years of experience and turnover. It is further seen that by the said bid document, it was also mentioned that there would be an EMD exemption for a bidder subject to submitting valid supporting documents for the relevant category as per the GEM GTC with the bid. It was further mentioned that in respect to the MSC category, only manufacturers of goods and service providers from the EMD. Clause 5 of the said bid document being relevant is reproduced herein under. Page 29. A perusal of the said clause 5 would show that the bidder or its OEM themselves or through resellers should have supplied same or similar category products for 80% of the bid quantity at least one of the last 3 financial years before the bid opening date to any central of the state government organization oblique PSU. It was further categorically mentioned in the said bid document that copies of the relevant contracts bracket proving supply of cumulative order quantity in any one financial year bracket close has to be submitted along with the bid in support of the quantity supplied in the relevant financial year. It is further relevant to take note of that along with the said bid document, there are additional terms and conditions. The relevant term in that category pertains to the qualification criteria, which is clause 1. Clause 1.1, which is the subject, which deals with the subject, which deals with the issue involved in the present proceedings, being relevant, is reproduced herein under page 77. From a perusal of the said above quoted clause, it would be seen that the bidder, if it is not the manufacturer of the goods offered, also is required to have experience of supplying goods of similar nature to different government departments, oblique undertakings, oblique entities of the quantity as specified in the last 3 financial years, that is 2021-22, 2022-23, and 2023-24. It further stipulates in terms with the said clause that the bidder should have experience of similar nature of work of at least 50% of the value of the tender in a single contract of the work order. Single contract oblique work order to Bulgul. Further to that, it has also been mentioned that a proof of the same has to be submitted. Before proceeding further, it is very pertinent to take note of that the estimated bid value as per the bid document is 2,53 is rupees 2,53,83,500. The record reveals that the petitioner duly submitted the bid Annexures Roman 6 is the bidder's checklist. It is however relevant to take note of that the bidder's checklist does not mention as regards documents submitted in respect to the OEM's, petitioner's OEM's qualification. the course of the hearing, Mr. B. Gogoi, the learned Additional Advocate General, have placed before this court the minutes of the meeting of the technical bid evaluation committee. From the said minutes of the meeting, the said minutes of the meeting is kept on record and marked with the letter X. A copy of the said minutes of the meeting has also been furnished to Mr. S. Bora, the learned counsel, appearing on behalf of the petitioner, so that he could also peruse the contents thereof. A perusal of the said minutes of the meeting would show that there were 10 numbers of bidders who had submitted the online bid under the two bid system, technical and financial. Out of the 10, 9 were not eligible. And only the respondent number 5 was found to be technically responsive. It is pertinent to mention herein that the petitioner bid was rejected on the ground of there being no single work completion certificate of the bidder having been submitted amounting to rupees 1.26 crores as per point number 5 of subclause 1.1 under clause 1 of the additional terms and conditions. This court further finds it pertinent to take note of that on 19/3/2025, the petitioner was duly intimated that his bid was, the petitioner was disqualified, taking into account that he failed in demonstration which was mandatory as per the bid condition. Further to that, the comments were also mentioned that there was no single work order, work completion certificate submitted amounting to rupees 1.26 crores. The court finds it very pertinent to take note of the document enclosed as Annexure Roman 9 by the petitioner. A perusal of the said communication, a perusal of the said document makes reference to a perusal of the document shows that the petitioner herein had also accepted that he had overlooked clause 5 of the bid document. And as such, on 26/3/2025, the completion certificate submitted in the bid uploaded document on 26/3/2025, the petitioner uploaded the completion certificate issued in favor of the OEM dated Well, 2022. In other words, it is very pertinent to mention that the said document dated 12/3/2022 issued by the Bihar State Building Construction Corporation Limited was not uploaded by the petitioner at the time of submission of the bid, which ended on 4/3/2025. Be that as it may, the petitioner being aggrieved by the rejection of his bid on technical grounds, the rejection of his technical bid, had approached this court and filed the present petition. The record reveals that this court, by an order dated 7/4/2025, issued notice and further passed an interim direction that no work order shall be issued to the respondent number 5. The interim order thereupon have been continued from time to time. The record reveals that the respondents have filed their affidavits whereby the decision so taken by the respondent authorities to technically disqualify the petitioner have been supported. This court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. The question which arises before this court is as to whether any interference in exercise of the powers under Article 2 to 6 of the Constitution is required in the facts and circumstances of the case. The materials on record clearly show that the petitioner did not comply with clause number 5 as quoted here in above of the bid document, inasmuch as the petitioner did not submit any certificate as regards the supply made to the quantum required in terms with clause number 5, either of the petitioner or of the petitioner's OEM. Further to that, it also appears from the records that the petitioner has failed to comply with clause 1.1 as above quoted of the additional terms and conditions, inasmuch as the petitioner have failed to produce a single work order oblique. Is that work order oblique? Work order oblique contract of supplying 50% of having experience of supplying 50% of goods of similar nature. Which is to the tune of, which ought to have been not less than rupees 1.26 crores, taking into account that the bid value, estimated bid value was rupees 2,53,83,500. Under such circumstances, it is therefore the opinion of this court that the reasons so taken by the respondent authorities to disqualify the petitioner as being technically not responsive cannot be said to suffer from any illegality or exercise of jurisdiction under Article 2 to 6 of the Constitution. Accordingly, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed. Interim order passed earlier stands vacated.
That original technical bit document. That original technical bit document.
Please take everything.
But
I am only keeping X.
yes,
So I to say
minute.
Problem.
Problem.
But IA also need to be
Yes, I am
disposed.
There is a mechanism.
I will go. I've vacated the interim order. Yours for vacating, na?
Lordship.
Why should I will get. I've vacated the interim.
List item 14 for implement of party. Maybe Lordship, due to some mistake, I want to withdraw. I will leave it to filing place.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that there are certain formal defects in the interlocutory application for which he would like to withdraw the application. Accordingly, the said application stands closed on withdrawal with liberty given to the petitioner to refile. It's advised.
Item
Mr.
15.
G. Sharma appears for response numbers
1, 2, 3.
1, 2, and 3. 4. Yes, what do you want?
Please, Lordship, in the order dated 11/8, Lordship, I plead the newly appointed chief engineer and special chief secretary of the public health department.
Who is Papa? Mr. Abbasi is the special chief secretary.
Chief secretary,
PWD. Mr. Who appears for PWD? You. Is Mr. Abbasi the special chief secretary, PWD?
not PW, public health engineer. He
PHE. Oh, this is PHE. Any PHE council?
I have article in there.
Oh, there, Mr. PHE. Mr. D. Gogoi. No,
He was here, my lord.
No, it's okay, no problem. Is Mr. Abbasi the special chief secretary?
Yes.
And Sanjeev Rajkwa is the chief engineer?
Rajkwa is not there, my lord. Some other person is there. I had some instruction in that file, my lord. That his claim is under process.
We'll take it after some time.
After some, I'm just calling him. Item 49.
Tricky.
So
So many. IS for what?
IA number 3080, my lord. File is IA for, my lord, amendment of the petition, my lord. Here, what happened, my lord? I have filed connected writ petition on 11/8/2025, my lord.
Yes.
Here, my lord, on 11/8.
You want to challenge some order?
Order, my lord. After filing of this writ petition, my lord, on the next day, my lord, order has been issued, my lord, appointing the, my lord, private respondent as a, my lord, transporter of the said contract, my lord. Therefore, my lord,
Transporter of the?
contract in question, my
Okay. So you want to challenge that?
lord. Challenge that.
Okay, we have to issue notice.
No, Lordship,
Lordship,
I'm
yes.
appearing for a private respondent number 4, newly implemented Lordship. They have not added us as respondent, Lordship.
Huh?
Lordship, in this case, they have challenged the technical rejection of their technical bid, Lordship. But before they filed the repetition, Lordship, already the tender process has been finalized. They have not, this fact has been suppressed by the petitioner, Lordship, and therefore Lordship has passed an interim order in this case.
I passed the interim order
Interim order, Lordship.
regarding.
But we have also filed a vacating petition, Lordship. But technically, as of today, Lordship, there is no interim order because they have not extended this interim order later on. And we were also not made party in the repetition, though we are a necessary party in this case.
Interim order extended?
No, Lordship.
Last occasion, my lord.
It has not extended, Lordship.
Last occasion, my lord, the IA was, they have filed, my lord, stay vacation application, my lord, that was taken up, my lord. And in that stay vacation, IA, my lord, we, my lord, sought for time to file objection, my lord. And my lord, accordingly, my lord, time was extended in the my lord stay vacation, my lord.
But Lordship, it is not extended. Though we have filed our vacating petition because the authorities are not allotting the works because of this.
Respond number 4 is already a party.
Lordship, my lord. Here, my lord,
Lordship, we have implemented in this case, Lordship, later on.
Then why do you need the implement of again? Whom do you?
that implement I have, that was implemented, my lord, on their application, my lord, and our application is still pending, my lord, that may be disposed of, my lord. Now, IA 3080 is for, my lord, amendment of writ petition, my lord. We have filed a writ petition on, my lord, 11/8, my lord.
But the interim order has been vacated,
Yes,
not
Lord.
extended.
Yes, Lordship.
It was, my lord, actually, my lord, on last occasion, my lord, the stay vacation petition was, my lord, taken up, my lord.
It was,
And on that day, my lord, we sought for time for filing objection, my lord. And accordingly, my lord, time was allowed, my lord.
but it
but
was
in the-
not extended, Lordship. Though we have filed our vacating petition.
It is.
And
not
also, Lordship, the financial bid was,
You file objection.
already filed, my lord. We have already filed,
Lordship,
my lord.
finance,
Kindly, my lord, have a look, my lord, paragraph 5 of my lord, IA 3080, my lord. In the present IA, my lord, application for amendment, paragraph 5, my lord. On 11, my lord, we have filed a writ petition, my lord. And paragraph 5 of the present IA, my lord, 3080, my lord.
What happened on 27/8?
27/8, Lordship.
Or 20, prior to that, my lord, their implement petition application has, my lord, come up, my lord, and they were implemented, my lord. Now our implement is still pending, my lord.
So there is no interim order.
Lordship, my lord.
There is no interim order.
And
Yes,
in view of the, my
You
lord,
have been more careful, Mr.
in,
Counsel.
in view of the, my lord, order passed in, my lord, their IA, my lord, for implement, my lord. The petition also, my lord, extended, my lord, interim was not extended, my lord, but my lord, matter was postponed, my lord.
And help you. But
So far, my lord, implement is concerned, my lord.
I
Amendment,
for
Lordship,
amendment.
IA for amendment 3080, my lord.
Hello. Amendment, you have no objection?
no, Lordship, we have objection, Lordship, because
is there to
financial,
object?
Lordship, financial bid was opened before they approached this honorable court, Lordship.
I
and
have been granted, issue the contract.
Lordship, already, Lordship,
That,
it is already,
paragraph 5, 5 of my IA, my lord. I have categorically mentioned, my lord. On 11, my lord, I have filed this application. On 12, my lord, they were appointed as, my lord, they were appointed as transporter, my lord. That was, my lord, not in my knowledge, under my knowledge, my lord.
When it
I
was
have I have filed my writ petition on 11/8, my lord.
writ petition.
Writ petition, my lord. 11/8, we have filed this writ petition, my lord. That was come up on, my lord, 14th, and interim order was passed on that day, my lord. In the meantime, my lord, on 12, my lord, they were appointed as a, my lord.
In violation of the order.
No, my lord.
Lordship.
It was
Before passing-
prior to that, my lord. We
before
have filed
passing
on
the
11, my
order,
lord.
Lordship.
That was move on 14, my lord. Paragraph 5 of my writ petition, kindly see, my
Lordship, on
I
7,
passed the order only on 14.
14, my
15,
lord. We have filed it
When were you appointed?
on 12, Lordship.
Then he was appointed earlier.
And this fact was not
we have
put on
we have
record,
filed on
Lordship.
11, my lord. On that day,
That
my
is a
lord, we have-
different thing, but he was appointed on 12/8
12,
before the
Lord,
court
12,
passed the order.
that was, my lord, not
In
in
our,
my knowledge, my lord.
in our packet, it was in their knowledge, Lordship. It was uploaded in the website of the district, deputy commissioner.
Has the
Lordship.
agreement been entered into?
Yes, Lordship. In our vacating petition, we have annexed it, Lordship.
When was the agreement entered into?
30, on the 12 itself, Lordship.
Show me that.
IA 3028, Lordship. This is the vacating petition. Here we have annexed the order, Lordship, as
30?
well as the agreement. 3028. Page 20, Lordship, Annex D. This is the order. And Annex E is the Lordship agreement.
12/8 agreement done.
Annex E.
Then
page
why are you asking for vacating?
Lordship, the authorities have not allowing us to work, Lordship, because of this stay order. Though it was not extended, Lordship, they have said that since there is no order vacating the order, this stay order, therefore though he has been awarded the contract, he is not allowed to work, Lordship.
Hello, we make it clear that as the order was not extended, we closed
Yes,
it
Lordship.
by
This will be Lordship.
full stop. It is seen that the interim order passed by this court on 14/8/2025 was till 27/8/2025. In the meantime, on 12/8/2025, the contract in question was already awarded to the applicant.
Lordship. Lordship,
And the
respondent
agreement
number
was-
4. Respondent number 4.
Here you are the applicant, na?
Yeah, here in applicant, Lordship. Seconding
Applicant.
petition.
And further, agreement was also entered into on 12/8/2025. The record further does not show that on 27/8/2025, the interim order was extended. It is also seen that there is no application filed by the petitioner subsequent thereto for the purpose of extension of the interim order. Consequently, it is therefore the opinion of this court that the interim order passed on 14/8/2025 no longer survives. So under such circumstances, the instant application has become infructuous into 3028. Now you want to amendment allowed, I'm allowing that amendment, don't object unnecessary. I continue. This is an application filed by the petitioner seeking amendment to the writ petition in view of the subsequent cause of action which took place on 12/8/2025 after the filing of the writ petition, taking into account that these are subsequent events which have a material bearing in the adjudication of the accompanying writ petition. And this court, it is the opinion of this court that the said amendments are required for a effective adjudication of the writ proceedings. Accordingly, the amendment so sought for by the application, by the instant application stands allowed. The petitioner is directed to file the amended writ petition on or before 26th of September 2025. Matter be listed thereafter on 17th of October 2025.
Lordship, my lord, can it be, my lord, before vacation, my lord? I can file my amendment petition, my lord, by tomorrow, my lord. Can it be before vacation, my lord, since my lord, interim order has been, my lord, vacated.
Interim is vacated, now nothing remains. It is your fault. You passed an interim long, you should have only asked the court and the court would have given.
Lordship,
Can't help it.
since my lord.
Okay, you want to file it, but I can't have it before vacation, nothing, no heavens will fall.
Lordship,
Once
we
you
filed
file
the
it, give him a
affidavit.
copy, she has to file, respond.
Yes, Lordship.
Okay, let it be on 24th. Be filed on or before 22nd of September 2025 by serving advance copy to the respondents. List the matter on 24th of September, I stands disposed. Main writ petition cannot like you. List this matter on 24th of September 2025. In the meantime, the petitioner is directed to file the amended writ petition on or before 22nd of September. What is this other two IAs?
One I was disposed of, my lord, and one
Allowed.
my lord.
IA is allowed, this one is disposed. And this one is for implement of respond number 4, 5, and 6. Why?
That is, my lord, that may be, my lord, infrastructure, because, my lord, he has already, my lord, contested, my lord, and filed implement, my lord. In their application, my lord, already, my lord, implement, my lord. So I'm not pressing, my lord.
Counsel appearing on behalf of the petitioner submits that in view of the order passed in IAC number 2818/2025, nothing further remains in the instant application for which the instant application therefore stands closed. IA 2841 order.
Oblige.
For admission, item 16.
Wait, please. Lordship, the case of the petitioner is this, my lord. A tender was floated by the railway with A, B, C conditions, my lord. Now, there was a clause in the tender that if the contractor wishes to have any deviation from the ABC terms, my lord, then he may submit a deviation statement. Accordingly, my lord, along with the bid, he has submitted a deviation statement that he wants deviation of certain conditions.
There's no interim order?
My,
No interim order?
interim order was initially, the interim order was the entire work was, thereafter it was vacated, my lord. And then I said that at least the recovery part may not be initiated. Then the court was of the opinion that on the next date it will be disposed of. So therefore, again, another interim order was not passed accordingly. In fact, even your lordship also heard this matter once. There is an order and then thereafter fixed it at 2 o'clock. Some 2 o'clock, probably I forgot the date. For
On
disposal.
19/8. But what happened on 19/8? It did not reach.
19, it did not reach. Then it came up before other bench. And then again, I was arguing for disposal. Then the other side was not there. He was out of station. And then again, this order was passed, the last order. Because he has seen from the record that your lordship has fixed it at 2 o'clock. Therefore,
What is this IA for?
IA was for that IA is, my lord, disposed of. It was for correction of the cost title. Just making a secretary party that has been done, my lord.
Nothing remains.
No, in that IA is.
By inserting Union of India represented by secretary. That has been.
That was the IA.
There is no order passed here.
IA.
Mr. M. Biswas, the learned counsel appearing on behalf of the applicant, submits that the instant application has become infructuous in view of the order passed on
The implement of the implement. We filed the application for implement. That application, no order is passed in that application.
Oh, but that impediment has not happened. How is it possible? You were saying infructuous.
No, infructuous means this implement of my lord. I'm sorry, because it was filed long back, my lord. I don't know why.
You have to make them, na? Ministry of Rail. Because the general manager NF Railway cannot be, na? Okay. I call Leho. Heard Mr. M. Biswas, the learned counsel appearing on behalf of the petitioner. Applicant, Mr. S.K. Mehdi, appears on behalf of the respondent. The instant application has been filed for correction of the name of the respondent number 1, which was inadvertently mentioned as the Union of India represented by the General Manager Works Maligaon Guwahati. 2. Union of India represented by the Secretary to the Government of India Ministry of Rail Bhavan, New Delhi 110001. Full stop. It is the opinion of this court that the instant application, the prayer made in the instant application is required in the interest of justice. Further to that, Mr. S.K. Modi, the learned counsel who represents the respondents, have no objection. Taking into account the above, the instant application is allowed, thereby permitting the substitution of the name, substitution of the respondent number 1 by the Union of India represented by the Secretary to the Government of India, Ministry of Government of India, Ministry of Rail Bhavan, New Delhi 110001. Full stop. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties within 7 days from today. 7 days. Within 7 days from today. And on the basis thereof, the registry shall make necessary correction in the course title as well as also update in the CIS. Full stop. Mr. SKVD submits that the main petition. Mr. SK, you have filed your written statement affidavit?
Yes,
madam.
Mr. SKVD submits that the affidavit which have been filed by the respondents in the instant proceedings shall duly take care of the stand of the newly impleaded respondent number 1, inasmuch as the earlier respondent number 1 was incorrectly represented only. Full stop. taking into account the above, when do we fix it?
My lord,
And don't put it to me in my head out here, because I may not be there after vacation for a long time. When do I fix it?
6th of November, my lord.
November. Maybe October 28th, Tuesday.
30.
On 30th of October 2025, Mr. M. Biswas, the learned counsel, submits that taking into account that the matter was earlier heard by another coordinate bench, and with a view that the matter would be disposed of at the early date, the interim order, no interim order was passed. He submits that as of now, no coercive action has been taken, isn't it?
Yes,
Yes.
No, that Mr. Musa, taking into account that all the pleadings are complete and the matter is required to be disposed of on a short question which have been already noted in the order dated 1/8/2025, this court. Directs that no coercive measures be taken against the petitioner till the next day.
I'm deeply aware.
I Yes, what is your instruction? Oh, yes.
Our instruction is that now, my lord, it has been sent to judicial department. My lord. This is the written instruction.
Because you- Views of the judicial department? How can there be a view of a judicial department be taken?
Nowadays, my lord, they seek a vetting
It is
of
the
the
direction passed by this. Duly taken note of the submission of the learned counsel for the petitioner, the petitioner is actually entitled, taking into account that upon verification it has been found that the amount to which the petitioner is entitled is none. To decide and adjudicate as to whether the petitioner is entitled to any further amount other than Iman. Accordingly, this court rejects the statement. And there is a direction in a more particular data. Now, on what authority, after an order being passed, you are asking for the views of the judicial authority?
unnecessary, my lord, but some
This-
new procedures.
I can do. Yeah. This is an application filed for the purpose of impleadment of the respondent number 2 and 3 in the opposite party numbers 2 and 3 to the accompanying contempt application. Taking into account that order passed by this court, dated 16/8/2023, passed in WPC number 6733/2023, have not yet been complied with, and there were specific directions issued to the respondent authorities to make the payment within a period of 6 months. It is the opinion of this court that the respondent opposite party number 2 and 3 are required to be included in the accompanying contempt application. Accordingly, this application stands allowed. The petitioner is directed to file a fresh memo of parties before the registry of this court by within 7 days, and on the basis thereof, the registry shall make necessary changes in the cause title and update the same in the CIS. This is the now main complaint. This court, by an order dated 11/8/2025, requested Mr. Ibotakur, who is the standing counsel of the PHE department, to obtain instruction as to why the said amount have not yet been released. Mr. Ibotakur, the learned counsel, has produced an instruction which is kept on record and marked with the letter X. From a perusal of the said instruction, it appears that the PHE department have taken a stand that in spite of a direction being passed by this court and an opinion would direct a specific and categorical direction being passed by this court, that the amount of rupees 7,51,110, which is admitted by the respondent authorities, be released to the petitioner within a period of 6 months. The PHE department have sought for a judicial opinion from the judicial department. It is not understandable as to what opinion is being sought from the judicial department, taking into account unless and until the PHE department is of the opinion that the opinion of the judicial is of the view that the opinion of the judicial department can override the specific directions passed by this court. So considering the above, this court therefore issues notice upon the respondent number 2 and 3 as to why contempt proceedings should not be issued against them. Contempt proceedings should not be initiated against them for the gross and deliberate violation to the order passed by this court dated 16/8/2023 in WPC number 6733/2022. And further, for undermining the majesty of this court. The petitioner is directed to effect service upon the respondent number 2 and 3 by way of dusty routed through the registry of this court, along with a copy of the present order. The registry shall fix this matter again on 17th of October 2025. In the meantime, the respondents number 2 and 3 are directed, respondent number 2 and 3 is given the opportunity to explain as to why their actions are not, why contempt proceedings should not be initiated against them. If I get this matter on the next stage, then I think we'll initiate contempt against it.
All right. Admission item 17.
My lord, here, my lord, we have filed the affidavit, my lord.
You filed the affidavit?
Yes, my lord, today, my lord.
Like to find a parawise reply or not. It's the same matter.
Mr. B.K. Das, the learned counsel appearing on behalf of the ONGC,
My lord.
submits that the affidavit has been filed on their behalf, copy of which have already been received by Ms. S. Dasgupta, the counsel appearing on behalf of the party. The learned counsel submits, the learned counsel for the petitioner submits that she would obtain instructions and, if necessary, file the affidavit in reply. List this matter again on 12th of November 2025. In the meantime, the petitioner would be at liberty to file their reply. The registry shall file their reply on or before 7th of November. The registry shall bring on record the pleadings.
18.
Non-payment.
Yes, Lordship. Admitted amount, Lordship.
My instruction is evident. Today I'm
Okay.
handicapped, I missed the file.
Verifier pay 6 months. Disposed. এইটো আমাৰ যোনটো work order verify কৰিব লাগে।
19.
May I please, your lordship. The lordship matter pertains to an Ujala scheme, lordship, that was initiated by the government of India to provide clean cooking fuel to the women belonging to the BPL, especially in the rural areas, you know. So there are the, what happened, lordship, later, it was found that there are lots of multiple connections by the consumers. So what IOCL has done, they have directed the petitioners distributorships to deduct those connections, but it is not the
You file the affidavit.
My lord, we are yet to file a affidavit, my lord. There is some latches on my part, although I have received the paraphrase comments. But my lord, if your lordship permits me, I'd
List the matter. Mr. M.K. Chaudhary, the learned senior counsel, submits their IOCL to file their affidavits. To file a response to the in the present proceedings. This court takes note of the notice was issued as far back as on 13/9/2023. And on the last occasion, the matter came up on 19/1/2024, when the IOCL again sought for 3 weeks' time to file affidavit. However, no affidavit has been filed. Accordingly, list this matter only after the affidavit in opposition is filed by the respondent IOCL. In the meantime, the interim order passed earlier shall continue till the disposal of the petition.
Let it be till the next date, my lord.
No. We have no urgency, nothing doing.
interim till disposal.
Till the disposal.
20.
Yeah, please, your lordship. My lord, this matter is covered by your lordship order passed in Amar Dekar.
What?
My lord, this matter is also covered by your lordship's order passed in Amar Dekar.
What is
It is
Amar
regarding 2% royalty matter.
Oh, 2%.
Yes, sir.
Same order.
Same order.
Same order.
I pass shorter orders. This is the longer order. Na? What have you done? What are you constructing?
My lord, residential flat, my lord.
Huh?
Residential flat, my lord, RC7.
Paragraph 2. Where 3 2 How many petitioners are here?
Yes, sir.
Huh?
Only one, please.
Petitioner number 1. Both GMC and GMDA, you have sought permission?
My lord. My lord, I have applied for permission, my lord. Then they ask for this 2% royalty, my lord. Then I can be put.
Paragraph 2 or 3 to like. The petitioner hearing agon naam kita korte. The petitioner herein is engaged in the business of construction and selling of real estate and apartments in the state of Assam. The petitioner recently applied for permission for construction of a new project for construction of a new residential building apartment before the respondent number 7 by submitting all the required plans, documents, etc. of the said project. Accordingly, the said permission applied by the petitioner firm for the new project was duly affirmed. But the respondent number 7 informed the petitioner firm to pay forest royalty at the prescribed rate of 2% upon the project cost as prescribed under third schedule attached to the Assam Minor Minerals Amendment Rules 2021. Else, the authority would not issue grant the permission for the said project. It is under such circumstances the petitioner has therefore approached this court. Affidavit filed? No affidavit.
No.
There are 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Bike in each. Dispose. So and so and so and so.
21.
Yes, Mr. Sahu.
Hello, this is relating to election of
Affidavit in opposition file.
yes, sir.
Whenever I fix these matters,
Case for admission hearing. For hearing in another case by APJP. This is for in case.
there is no interim order, na?
Same.
Whenever I fix it, any date?
No date has been taken.
Okay. Heard Mr. T. Sahu, the learned counsel appearing on behalf of the petitioner, and Mr. H. Gupta, the learned central government counsel, who appears for the respondents. The respondents have filed their affidavit in opposition in the instant proceedings. The petitioner, however, have not filed any reply. Be that as it may, the issue involved in the instant proceedings is also the subject matter of various other writ petitions which have been pending, wherein this court have duly admitted those writ petitions and fixed the matter for hearing. This matter. So accordingly, the present writ petition is also admitted. Also admitted for hearing. List this matter along with
Along with the APJT, petitioners APJT. Provide number.
WPC number so and so. In the meantime, the petitioner would be at liberty to file the reply if so advised.
22.
In this matter, I have, after going through the report, I have come to know that so far the notice against the respondent number 7 and 8, private respondent not issued. Other 1 to 6 has service is complete.
What is this case?
The non-renewal of NOC and
the-
trade license by local
Authority.
Which authority?
The PCDC and PCDC, Village Development Council. BTC
Who has delayed? Who has to issue?
This respondent number 6,
And you did not make 6 initially a party.
No, the 6 we have made party,
Well, this is a corrected. So
corrected, respondent number 5, so far the address of the respondent number 5,
Huh?
Respondent number 5 was address was wrongly, my lord, quoted. That is why it was directed to correct.
The phone number 5 has been. No issue, notice has been issued.
No, my lord, it is sir, my lord, complete, my lord.
Then?
Respondent number 7 and 8, my lord, private respondent, my lord.
Why you have to say 7 and 8?
7 is the, my lord, village development committee chairman, and my lord, 8 is the my lord, executive member, my lord. They have some, my lord, the demanded, my lord, money from the petitioner for issue.
Where have you mentioned in a petition?
My lord, lordship will find. At paragraph 10, my lord. And one representation was also filed, my lord, in that regard. The chief will find at annexure 8, page 29.
So your allegation is against 7 and 8?
Yes, ma'am. Non-payment, they are not issuing. They are not renewing. Earlier it was there.
Has it been served on the chairman of Village Council Development Committee?
6, my lord, it is served.
This is under whose authority? Mr. Under whose authority is this department, BCDC?
This is, my lord, a local body, my lord. So
No, there cannot be a local body who can do it. It has to be under some authority.
yes,
The
usually,
panchayat.
Panchayat, my lord.
since it comes
you.
under BTC, my lord, the appropriate authority will be actually, my lord,
Block level.
BTC. BTC will be the authority, my lord. Because the convention is that, my lord, in wherever local bodies is mentioned in Assam Excise Act, that function is performed by BTC because they do not have local panchayats in under BTC, my lord.
So are you not required therefore to make the BTC a party?
BTC is met party, my lord. That's
Where?
He appeared, my lord. Mr. MS Boro, my lord.
Where is he?
BTC.
On behalf of respondent number 1 to 6, my lord.
Huh?
Respondent number, my lord, 3, 4, 5, 6.
3 to obviously
Copy has
also deputy commissioner somebody. You are appealing for whom?
Respondent number 4 and 6. 4 and 6.
4 and 3.
6.
5 also
Now,
copy.
4 and 6 you are appearing. Yes, why are you not extending the, giving the trade license?
What's in my senior season legs in
Who is your senior?
RB Bora. RB Bora.
Where is she?
Is in another court of passport.
If you are not appearing, we direct them to issue the trade license as it is. Unless they 7 and 8 not necessary. You are not there to help, so no necessary. Have you filed your affidavit?
No.
Well, nothing doing. Leho. Heard Mr. N.K. Kolita, the learned counsel, appearing on behalf of the petitioner, Mr. I. Thakur, who appears on behalf of the respondent number 1
and 2.
2. Ms. Yudas appears for respondent number 3. You appear for 4? No.
4, my lord, superintendent of elections.
4 also?
4 also, yes.
1, 2, and 4. Ms. Yudas appears for respondent number 3. And Miss So-and-so appears for respondent number 5 and 6. There's no on behalf of, or none appears on behalf of the respondent number 5 and 6.
I have also copy received by my lord, the army.
It's okay, none appears. Unhelpful. They are not appearing. The petitioner's grievance herein is that the petitioner is running have been issued a IMFL off license by the respondent excise department. But on account of non-renewal of the trade license for reasons best known, the petitioner had to approach this court by filing the present petition. It is seen that by an order dated 17/11/2023, this court issued notice and further directed that the trade license of the petitioner be renewed. And further directed that as the petitioner had applied for the renewal of the trade license, which is valid from 5/2/2020 to 4/2/2023, and as the respondents number 5 and 6 have not taken appropriate steps, there was a specific direction that the said respondent number 5 and 6 should not interfere with the business of the petitioner without the leave of the court, merely because of lack of renewal of the trade license. The order having been passed on 17/11/2023, till date, the respondent number 5 and 6 have not cared to file any affidavit in opposition, nor have appeared before this court. Considering the above, it appears therefore that there was no reasonable justification for the respondent number 5 and 6 to not to renew the trade license of the petitioner. Full stop. These trade licenses are given for 3 years.
3 years.
Full stop. Accordingly, this court therefore disposes of the instant writ petition, thereby directing the respondent number 5 and 6 to issue the trade license to the petitioner on his application and on its application. Subject to petitioner filing submission of the subject to the petitioner paying the requisite fees which is required. Accordingly, the instant writ petition stands dispensed.
Lordship, I am very sorry, Lordship. I was in another court, Lordship. Respondent number 7 and 8 yet to serve notice, Lordship.
Not
And
necessary. I'm not going into the question of malafide.
Lordship,
The 5 and 6, you are the person who are to required to give the trade license. Why haven't you given?
Lordship, 1 week time, Lordship. Last
No, 1 week. Finish. Order passed. He has submitted his trade license application renewal, grant the renewal after taking all the necessary fees which is required. No, you have no other business. Trade license is a form of a fee. Why you're not taking the fee?
Lordship.
Ali RB Bora's naam to likh diyo.
Lordship.
Yes, what is this?
My lord, over here, this petitioner is a widow. Her husband was the franchisee in respect under the APDCL. My lord, he died in the year
They have
2000.
not filed your affidavit.
Lordship, I've just received the instructions. The accounts have been finalized and the payments have been made to the, whatever we admit, your Lordship, those payments have been made to the petitioner. Just received, I've just taken a printout.
What is the amount due, Mr. Abidin?
My lord, first of all, they have denied 14 months my performing the duties, my lord. That is, I have already given the documents by which I have paid the amount. I don't know on what basis they have denied. So that is a huge amount, my lord. I am getting only 50. This widow is entitled to get 15%.
You file your affidavit.
Very well.
Mr. KP Pathak, the learned counsel submits that standing counsel of the APDCL submits that he have already received certain instructions and he would be filing the affidavit within 2 weeks. List this matter on 10th of November 2025. In the meantime, the PDCL shall file the affidavit by 3rd of November 2025 without fail. It is observed that if the affidavit is not filed, this court shall shall dispose of the instant petition on the basis of the materials already available on record.
24. Deputy of Light.
Yes, Your Lordship, somehow, my lord, I missed to file the affidavit, my lord. By Monday, I'm going to file affidavit, my lord. Let the matter fix on next week, my lord, any date, my lord. By Monday, I'll file, my lord.
10,000 cost.
My lord, kindly by Monday, somehow I missed it, my lord.
10,000, na?
My lords,
Notice was issued in 2024
Yes,
and you cannot file the affidavit.
last time the honorable was directed to file affidavit, my
I
lord. Now-
directed the file the affidavit.
Yes, my lord, by
file.
10th of 9.
Matter is already getting delayed.
My lord, kindly, somehow I missed it, my lord. That is my, I
You cannot
apologize for
miss
that, my lord. By Monday, I'm going to file, my lord. By Monday, my lord.
Okay. Miss Again submits the affidavit, which was required to be filed by 10/9/2025, could not be filed and would be filed by 22nd of September 2025 without fail.
Yes,
List this matter on 24th of
Yes, ma'am.
September 2025 for
my
an
bless,
update.
my lord.
Deputy. 25.
Well, affidavit filed, admissible amount is at page 139. It's not in the record, may I please my copy, ma'am?
One,
It is 25 lakhs. Page 139.
130?
9. No, it's not there in the record.
No, we have only till 103.
No, it's there in my affidavit, I filed, ma'am. I have copy to that.
How much? 25 lakhs.
Yes, that is our, my lord, admissible amount.
They file affidavit.
Yes, ma'am, this is affidavit.
Affidavit has not come on record.
Yes.
Okay. It is because of on the basis of this paragraph. Baki khani likhi.
Para 12, my lord, we have mentioned, as well as 14, para 18, sub para D,
Para 12.
12 and 18D.
As per the incomplete bill, so as well as the update bill value of the petitioner would be 2 crores, and since previous bill value of rupees 12 crore, and as per such and after preparation of the final settlement amount of it is payable.
And my lord, regarding SD money, it is para 13, my lord.
Huh?
Para 13. Paragraph 13, we have given the reply. So both the claims have been answered.
That is 13 lakh. It's been deducted as 20% penalty. Has been deducted. Against the amount. Along with penalty amount is the remaining up. So he is only entitled to this 25.
Yes, only 25 lakh. If there is any grievance, he will have to raise it before the civil court or by arbitration. whatever.
Petitioner asked for how much?
4 crores, I suppose. my lord.
Huh?
My lord, 3 crores, my lord, the tender value was 3 crores, my lord.
Okay.
And my lord, I have
1 crore.
1 crore balance, my lord.
12
But actually,
crore,
my lord,
20 lakh,
my
21,000.
work order was
12
terminated. my lord.
lakh as penalty.
My work order was, my lord, terminated. My lord, due to fraud, my lord, I could not complete the work, my lord. That is at page 37 and 38, my lord.
Okay. I think then you need to file a reply.
Reply.
You file a reply on the basis of this. Because if you want to say
No, my lord,
anything else-
termination is not on the challenge. Termination is not on the challenge.
No, if he says
Yes,
anything more that he
My lord,
required, that the security deposit is required, could not have been deducted. If he wants to say that,
Lord.
then obviously he needs to file a reply.
My-
Don't you think, Mr. Roman?
My lord, I will file a civil suit, my lord. Let this matter be disposed of, my lord. I'll file a civil suit regarding the, my lord, that amount, my lord.
Balance.
You are happy with 25 lakh.
My lord.
Then, as regards the remaining amount, you will go before the.
My lord.
But you cannot question the deduction of the penalty. That is why otherwise,
My lord,
for me,
kindly, my lord,
it's a
see, my
job.
lord. At page 37, kindly see page 37, my lord.
No. Here
For my
you have-
satisfaction, my lord, kindly see page 37, my lord.
Mr. Triple S Raman, kindly see prayer 1. Read in the nature of certiorari or a direction should not be issued directing the respondent to make payment of rupees 12,24,065
My lord.
deducted as penalty in total.
My lord.
Meaning thereby you are challenging the penalty.
My lord.
So therefore you cannot, if I dispose, I cannot allow you to raise that before the civil court. You are happy with it?
No, I'll file reply.
Ah, otherwise for me it's 2-minute job. Ask him to do it. Ikaw na ako. Mr. P. Gogoi, the learned additional advocate general submits that respondent PWD have already filed their affidavit in opposition and copy of which have already been furnished to Mr. Tutules Rahman, the learned counsel for the petitioner. Full stop. Mr. Rahman, the learned counsel submits that you would like to file a reply. List this matter again on 14th of November 2025. In the meantime, the petitioner will be at liberty to file the reply by 10th of November 2025. Itu ready ba?
Plus.
Oh.
Your lordship, this is a non-payment of contract.
Yes, what is happening?
Lordship, we have paid 10 lakhs for four numbers of contract, Lordship, and 2 numbers of contract we pay from the budget provision from 2025-26, Lordship. And Lordship, we cannot.
You have filed an affidavit.
Yes, Lordship.
Let us see what is your affidavit.
And here is some typological error in page 47, Lordship.
There are
Page 47, some typological error also, Lordship.
and then in the answer make to say that he has always high esteem both for and so and they go not to keep and they believe with the omission on part of it and that. Madam, you have got for 4.
4.
You have got, when did you get it?
In the month of March, April.
Recently?
Recently, after filing the present petition.
So for 4 you have got it.
Yes, I have
We 76, 186, 200 and 201.
Yes.
You have got it.
Yes.
Now as regards the remaining, which is that serial number
In
269 and 334.
Yes.
That they are taking steps for financial sanction.
Yes.
Okay. Okay, then we do one thing. Let's have it in the month of December
Yes.
and see what happens.
18th of December. Month of December.
December, let us see.
Yep.
If they pay in the meantime, it is good. I'll pass that order also. They can pay.
But this is too late, my lord. Already the petitioner is on.
Madam, if I dispose it of, you'd never get the payment.
Yes, I
I'm
understood.
keeping this matter alive so that to put pressure upon the BTC. You have to know how BTC works. They don't work unless you put some pressure.
Yes.
In respect to other departments, you can say, be rest assured that after 6 months they will do something. But BTC won't. So you have to keep the matter till they don't pay. It is seen that pursuant to the order dated 18/8/2025, an affidavit in opposition has been filed by the respondent number 2. In the said affidavit in opposition, it is being mentioned that there are 6 work orders in respect to which the petitioner is entitled to certain amount, out of which, in respect to 4 work orders, which were at serial number 76, 186, 200 and 201, the petitioner have already been released the said amounts. However, in respect to two work orders, wherein the petitioner is entitled to the amount, the same are put at serial number 269 and 364. It is further stated in the said affidavit that the case of the petitioner would be considered financial sanction as earmarked budget provision of the financial year 2025-26 and as per the chronological order of liabilities. This court inquired with the learned counsel appearing on behalf of the petitioner as to when an update can be given as to when the financial sanction has been granted for the payment to the petitioner. The learned counsel submits at least 2 months may be granted so that she can give an update. Accordingly, list the matter on 2nd, 3rd of December 2025 for an update.
Lordship, in for petition, my lord, they have paid only 10 lakhs of entire amount, not full amount.
Oh, Lordship, yes. Yes, Lordship.
On
10
10
lakhs each.
Each 10
Lordship.
lakh each.
We are Lordship.
Total in for petition, they have paid only 10 lakhs of total contractual bill amount.
Each contractual bill 10 lakhs, Lordship, because we
Yes.
are suffering from financial constraints. So we are paying little bit amount every contractor, Lordship.
Miss Bora, kindly don't say about financial constraints of BTC.
I'm-
Has the problem in accepting a bank draft in the name of somebody which is otherwise properly a negotiable instrument, but wishes to give it to a person at rupees 1,23,000, but not to the person who has given 4,56,000.
But bank draft is normally should give
So,
from own.
so don't
own
say about money. BTC has lots and lots of money.
Yes.
The question is, you are not paying to the people who are entitled.
Only 10 lakhs paid.
Each.
Is contractual amount, not in.
So, has been paid in respect that only 10 lakhs have been paid in respect to 4 contracts with at serial number so and so and so.
Each contract.
However, in respect to the remaining financial sanction, the learned counsel this court inquired as to when the remaining amount, which is the verified amount, in respect to the 6 contracts, would be paid. She submitted that some time may be given so that their petitioner, respondent BTC, can obtain an update, so that she can obtain instructions. List the matter on 3rd of December.
Yes. Directly upon.
Seven, my lord, on 9/9, my lord, I have filed the affidavit for respondent number 2.
Industries Department filed affidavit.
My lord, in that affidavit, my lord, inadvertent mistake has occurred, my lord. The page 1 of the annexure A, my lord, inadvertently, my
With
lord.
my rejoinder affidavit.
Page
filed by the
173, my
Ministry
lord.
of Commerce and Industry.
My lord, yeah. I got it from her.
5 and 6 also filed.
You filed the reply.
Oh, I filed it.
The reply again. right?
Yeah, and rejoinder affidavits you have
No,
filed, both.
My lord. Pleadings are complete, my lord.
Industries Department affidavit.
Filed, my lord. In that case, my lord, one inadvertent mistake has been committed in annexure 1, my lord. Page 1 of the annexure A, my lord, is not, my lord, inadvertently, my lord. It was
Lecture 1.
173 page, my lord.
73 page. Lecture.
173.
Yes, what is it?
My lord, one is, my lord, somehow my lord, it's missing one, my lord. I may be allowed to bring on record the complete annexure of annexure A, my lord.
Of lecture A to the
A,
affidavit.
my lord, to the affidavit.
Okay, Miss Yudas, the learned senior government advocate submits that the respondent that in the affidavit in opposition filed by the respondent number 2
Ma'am.
dated 9/9/2025, inadvertently the entire annexure A have not been brought on record. She therefore submits that she may be permitted entire
My lord, page 1, my lord, some lordship will find that top, my lord, Government of Assam, Office of the Assistant Commissioner, then my lord, suddenly, my lord, the next page has come up, my lord. It's making
that
photocopy. my
submits
lord.
that
Yes,
the annexure A
my lord,
document does not appear to be complete.
my lord.
She therefore submits that she may be permitted to file an additional affidavit bringing on record the entire annexure A.
A.
To list this matter on 26th of
My lord,
September.
26, I have some problem, my lord.
You don't require, na?
Yes.
You don't require. I'll give time. 26th of September. Let them file. Let them file.
We will file till 26.
On 26th of September 2025. In the meantime, the additional affidavit be filed by 25th of September. Let them file. Then we'll see.
My lord, I'll be out of this.
He's there, na? Nothing, no heavens will fall. Don't worry, I'm not going to dispose it on the last date. But let them file. Otherwise,
31.
this will go away, means it will come up to 6.
Obliged.
You want after some time? Okay. In 6 weeks' time is granted to file the additional affidavit. To never come there.
We became the.
It can relax.
Yeah, my lord, let it go to this.
6 weeks' time.
No, let it go to.
And therefore, don't do it. Okay. 26th.
Obliged.
Yeah. Let them file it by 25th.
Obliged.
Okay.
Yes, 3 petitions.
Yes, my lord, petitioners here are PDS licensors. They deal with fair price shops, my lord. They offer grains in PDS rates. They have not been given a point of contact sales machine, which is given to all fair price shop owners, my lord. So we have been seeking instructions, but nothing has come so far, my lord.
What do you want?
We want, my lord, that machine. It's called the PC.
EPOS.
Yes, yes.
They have not given it to
No.
you. The reason is that your fair price shops have been tagged with somebody else.
Yes, in 29 it is tagged. In 30, 31, my lord.
Same. You have how many consumers? Beneficiary? Less than 50.
Beneficiary, my lord, I'll have to.
That is the reason why. Isn't it? 50. Huh? Minimum 50. So they have therefore not given the EPOS machine.
But, my lord, let it be brought on record. Otherwise,
Not necessary. There is a judgment out there. Mr. B. Gogoi, that what happened to the judgment which I delivered on this 50 and above? The appeal was prepared, I think. Just dismissed, I suppose. That was that decision taken by the cabinet that below 50 they are not. The machine will only be given to those people who have it. Otherwise, they don't give it. Because without the EPOS machine, they cannot be supplied.
yes, ma'am.
Because all these are rooted with the NFSA.
Yes.
So, anyway, what do you want? Bad case?
Anything, my lord, if they produce on record, my lord, at least I can go through it and because.
Hello. K. Gogoi, where is he? Who is appearing for the government? Yes. Why you are not filing an affidavit? Give some satisfaction to Mr. Ibotakot. He always gives satisfaction to the respondent petition, the court, by providing instructions. You
My
should
lord.
be fair also.
My lord, 2
Taking
established.
into account that he is a co-respondent counsel all along, doesn't mean that you are going to do it in this manner.
My lord, 2 weeks time may be granted, my lord.
Okay. You means actually 4 weeks.
My
Because
lord,
the 2 weeks means
correct, my lord. Yes, my lord.
Ms. Yuda submits that the affidavit could not be filed. The stand of the respondents could not be brought on record.
My lord.
And as such, seeks a final opportunity to bring on record the stand to establish this matter on 31st of October 2025. The affidavit be filed by 27th of October 2025.
Obliged.
32.
One affidavit will do for all these 3 papers.
My lord.
Oh. Another one. Yawar Pasa, Muslim Ali, Rana Construction. They are the contributors for which we have to now go to a new high court.
That's more, especially.
Otherwise, the high court could have been of a standard of the Kohima High Court, the smaller one. And if these three petitioners are not. Yes, what is this?
My lord, they are not providing. First I was terminated. Thereafter they withdrawn the termination. Then again first termination. Then I sought permission from this court saying that I will be allowed to withdraw it because there is certain development which has taken place because modified BOQ has been given. And then we filed this petition with the permission of the court. Now, in the meantime, we have also come to know it has given to some other contractor, my remaining portion of the work. I said, please disclose what the name of the contractor, which is the name of the contractor. They have stated in their affidavit, it has been given to some other work. The work which was entrusted to you is given to some other party. I said, please give the name to me so that I can then make them a party also.
Some other day, my lord, I will provide the name also. Otherwise, I filed the affidavit, termination, my lord, of December 2024. Probably by this time, the work is already over. And my lord, that has not been put to challenge, subsequent development. Let be Monday also, but that name I can provide. Today, I called up, my lord, but because of the puja and all, the officers are busy, my lord.
Next week, what do you say?
Because there is no other claim for payment of any, my lord, unpaid.
No, there are.
No,
There are.
here in this
That's it.
petition.
9 crores something they paid.
Have they mentioned in the affidavit that they have given it to
Yes,
some other
yes,
party?
yes. They have given.
Where is the state?
They have mentioned, yes. That's why. They have mentioned.
Paragraph?
Paragraph 35, 181 of the affidavit.
Well, 35.
35.
Now, why do you want the L1 bidder?
Which one? Sorry.
Why do you want the name of the L1 bidder?
No, but it has been the work. So I don't know what will be the outcome. Maybe it goes against us, favor us. I don't know. But the remaining portion of the work, which has not been done and which they have terminated, and it has been given my work to somebody else. So that is why, suppose today, tomorrow.
Are you challenging the termination?
I will challenge. No, I have challenged the termination. My termination I have challenged. They terminated my contract. It was a construction of work. They have terminated. First termination order, kindly see.
No, what is your prayer?
Page 32.
Termination, 1712,
Yes.
by the respondent as to why retainer should not be issued to allow the petitioner to complete the balance work after resolving his problems at the work site. So you want to do the balance work?
Yes. No, balance is position.
And there is no stay.
There is no stay.
Yeah?
There is no stay.
Prayer for interim order would be considered.
Only what, my lord?
And the
I
best
don't
part,
know.
till returnable, then coercive steps.
No, yes, I don't know what, with great respect, my lord. With great respect, no, I can't say that, my lord. I will not make any comment on this, my lord. No coercive measure, I will not make any comment on this. Let us not make any comment on this issue. But the fact is that well, your lordship can take up on Tuesday, this Tuesday.
Oh, this matter came up before me.
Yes,
but
yes,
I'm not going to extend the interim order.
No, there no extension order, no extension.
But you may be entitled to only damages.
Maybe. Lordship can hear it.
No,
Whatever
what
result.
means now, taking into account that 9 months have already gone by, the work has been issued to somebody. Whatever may be, somebody has been issued the
Yes,
work.
somebody it has been issued.
Well, yes, somebody has been issued the work on 5/3/2025. What remains unless you want to put it in the newspaper, that the government PWD department has the habit of taking away the works of legitimate contractors and giving it to some specialized contractors. Unless you want to say it.
I don't want to say.
That's not your
No, no, then no, what I
So if
will
that is
say.
not your
No, no,
satisfaction,
what,
which you are
no,
going
no,
to
what
get,
I'll say.
your case is the civil court.
No, what is the case here? My lord, the case is this, my lord. I have been given the construction work. Now that work, 5 times they have modified. They have modified the estimate of the work. Initially 17 crores was the amount. Subsequently, they came to 16 crores, some amount. Again, they BOQ. When I was terminated, then they came up with another working estimate. Well, they are not sure the working estimate which is given to me. Now, then they decided, and there is a letter which I'll go to show before this court. It is a construction work in the Chor area. Now the road has been damaged. I can't do anything. I cannot carry any material. Now a request was made from the PW department to Deputy Commissioner to allow this particular contractor to take this material from by way of riverboat. Even that they did not allow. They said, yes, please do it. But they did not allow that also. Even in spite of the order, they couldn't provide. They couldn't provide. So this is not my fault. I'll show this is the fault of the state government, which did not provide. Now they decided to withdraw the termination order. And they said, you do the work. Only the reason now they are saying that a particular portion has been washed away by flood. That is, that particular, you
Well,
have to construct.
let us assume we hold it that the termination is bad. Then the work is done, what remains?
No, that is what. Why we want to make them a party. Suppose.
No. That has gone for a 6. But let us hold it, okay, your petition, I will allow it. Then what relief can I give?
That will be difficult.
Then nothing remains
that will be
unless you show that this termination order is bad, for which you are entitled to damages. That is the only way out. Because at the end of the day, you will be fighting out here. Fighting here, fighting here, fighting here. And the court will say that, okay, termination is very bad. Then that cannot be given. The court has to then stop out here and say that, look here, we can't pass you any order for giving because the work has already been done. And you cannot also, after 2 years, when the matter finishes, to do at that work at the same SOPD.
What it can be done. No, your lordship is right. So let us do one thing, my lord. Let me get some instruction from our client on Tuesday. Let it come on Tuesday. We'll then.
But the
We'll take a
name,
call.
he has no problem in giving action.
Yes, that I can provide.
You give a copy to him for his mental satisfaction.
Along with that, my lord,
He
letter
says
of
that the
acceptance.
petitioners will have a mental satisfaction. They look here, I know the name, but it has no, because you cannot, making him, including him also makes no sense here. Because it is the inter-party dispute between you and him, unless you say that this has been given only to, yes, if it is done at your risk and cost, then also the question is the termination has to be set aside. Then another aspect, it is just the termination at risk and cost. Is it done at the risk and cost?
Just termination. Termination.
153, 153.
153, my lord, termination.
Page?
153.
153. At risk and cost.
Then.
And the governor hereby given terminated work at your own risk
If
and
you
cost.
attend the money.
Risk and cost. Kindly see the second paragraph.
So this will remain.
Yes.
But then also you don't require the other side. That party also, then also you have to now get this thing set aside.
Yes, that's right.
Set aside is
Yes.
required. Okay. So what to do? You file your reply if you have to say anything on his affidavit.
Yes, it will be after vacation in that respect.
I think you file a reply.
Yes, I'll say that.
Because they have filed a detailed affidavit.
Yes, I'll.
It is seen that a detailed affidavit has been filed by the respondent number 3 supporting the termination of the contract dated 17/12/2024. Full stop. Mr. Didas, the learned senior counsel, submits that the petitioner would like to file a reply to the said affidavit in opposition, and sometime in that regard be issued. This court further inquired with the learned senior counsel as to what is the coercive measure, what is the interim order passed in the instant proceedings. Taking into account that the relief which have been sought for as an interim measure is suspension of the operation of the impugned termination letter dated 17/12/2024. The learned senior counsel appearing on behalf of the petitioner submitted that though in the interim prayer it has been mentioned about the suspension of the termination order dated 17/12/2024, but in effect, the prayer should have been that no coercive steps should be taken against the petitioner on the basis of the termination of the petitioner, a termination of the contract of the petitioner by the impugned letter dated 17/12/2024, as the same was done at the risk and cost of the petitioner. He further submitted that as the matter has been now, all the pleadings would be filed, the pleadings have already been filed, and there was no fault on the part of the petitioner which led to the termination of the contract. The imposition of any risk and cost upon the petitioner would be detrimental to the interest of the petitioner. This court, having heard the learned counsels appearing on behalf of the parties, is of the opinion that the opinion is having heard the learned counsels of the parties and taking into account the pleadings which have been filed, is of the opinion that the termination letter dated 17/12/2000, that the termination letter dated 17/12/2024, by which is of the opinion that the respondent authorities should not be permitted, is of the opinion that the petitioner is entitled to certain interim directions on the aspect as to whether the respondent authorities would be entitled to impose risk and cost upon the petitioner. Accordingly, this court, although is not inclined to stay the letter of termination dated 17/12/2024, but directs the respondent authority not to impose any risk and cost upon the petitioner till the finalization of the present dispute. The order should have been properly laid.
Yes. That's why I
33.
didn't comment. I didn't comment on it.
Says it, yes. Yes, Mr. K. Goel, sir.
I need some further time to file our affidavit.
Why?
Instruction
Non-payment, why?
Instruction is awaited, Lordship.
Cannot be awaited. Verify pay. It's either the people. All verify. This is not a direction to pay.
Lordship.
You verify, find it, yes, then you pay, after taking into account, making all the necessary statutory deductions, and then
Lordship, 6 months
6 months
after receipt of a certified code. After receipt of the
to the DGP police.
My lord, on
DGP police.
yes, the commission, district commissioner of police. and DGP police. My lord, on last June, the case was listed. They take time for 3 weeks.
Your matter is over. You'll get the money after 6 months.
1 and 3 direction.
Apply.
Direction to the 1 and 3 respondent number.
Who is 1 and 3?
One is the government lordship because they have to sanction. Then the DGP is the respondent number 3.
DGP, I think will do.
Lord.
Direction is the 1 and 3. All the respondents and also within 6 months from the date a certified copy is given to the DGP.
Obliged.
May please, your lordship. My lord, item number 34 and 35 were similar matters, my lord.
SD money, my lord. My lord, I have communicated. I'm not sure whether, my lord, that instruction has been punished or not, my lord. My brief is, my lord, along with the finance, my lord, it has got, my lord, mixed.
Lordship, my lord, there is a
Let
last
it be on
order.
25th, my lord. I will, my lord, if not, I will
Instruction
tell the
order was passed, my lord, to file affidavit without any fail, my lord.
Huh?
As for the last order, my lord, here the lordship has directed that affidavit be filed by 10/9/25 without fail.
Written instruction will do, my lord, where it has not been paid. Let it be on 25th, my lord. Only 7 days time I'm paying, my lord. Might be there provided, my lord. Only, my lord, 4 or 5 days. On 25th, before the vacation, my lord.
It is seen that the affidavit it is seen that on 22/8/2025 the respondent PWD sought for time for filing the affidavit and this court granted time till 10/9/2025 to file the affidavit. However, the affidavit has not been filed. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the amount which is being claimed out here is on account of the non-release of the security deposit. And there is no dispute that the petitioner has carried out the work to the satisfaction of the respondent authority. Taking into account the above, this court fixes this matter on 25th of September 2025, on which day, if the respondents do not produce the instruction as regards as to whether the petitioner herein is entitled to the security deposit or not, this court, on taking into account the doctrine of non-preverse, shall pass appropriate orders.
Hello, my lord, civil.
Both.
Lord, on the last occasion, I was directed to produce the original of this registration, madam.
You produce the records?
Lordship received the record, Lordship. 1% bank draft earnest money has not submitted additional, Lordship. Being ST candidate, Lordship, tender, Lordship.
Additional affidavit.
Yes, have you given it to the number 7?
Lordship, petitioner has not submitted the 1% earnest money being STP candidate tender, Lordship.
What?
There is precondition for tender that if ST, he should deposit 1% earnest money, Lordship. He has not.
He has not done.
He has not.
Lord, that I have submitted, my lord. That is my additional affidavit, Annexer 6. This
In the
30.
record.
From original record, my lord, that may be set up.
Yes, sir.
Additional affidavit, page 38.
The private respondent lords. And lordship.
Another thing, my lord, your lordship would consider page 36.
What is the name of the petitioner?
Petitioner is Premal Brahma.
Premal Brahmo.
P-R-E-M-A-L.
Premal.
P-R-E-M-A-L. Primal.
Premal.
Primal Brahmo.
Brahmo.
Rahul Brahmo. Vita.
Rahul Brahma is selected.
This is Rahul Brahmo.
So
Rahul Brahmo is who?
Rahul
Private
Brahmo
respondent.
3, my lord.
Okay. And this is?
This is
Respondent number 7, Rahul Brahmo.
This is Primal Brahmo. He gave 2,000 and 4,48,000. You are the petitioner.
Yes, madam. $448,049 and 3.
What did he not give? Some 2,000 rupees. You did not give some 2,240 rupees. Is that the reason?
yes, lordship.
Huh?
Yes, lordship. 1%.
Madam, I have deposited 2,300.
Huh?
2,300.
No, you he give it 2,000 only and 4,48,049.
Separate bank draft, lordship. One is for earnest money. One is for tender value, lordship.
Then another person, Ursam Boro, submitted 1,000 and 2,000. He did not come in anything else. What are these? What is the date of these documents? This is valid for how long? These are all
1 year.
non-negotiable.
1 year, lordship.
Huh? These are all non-negotiable now. Why do you keep these?
Lordship, they are not taking back, lordship.
No, understood. For petitioner, for respond number so and so also, he gave on 17 to 2025. Now, why haven't you put this?
Lordship, that should return. I have talked to them, lordship. They are saying that they are not ready to return back.
No, understood. If you don't put this becomes non-negotiable, valid for 3 months only from the date of the instrument. These are all 17 to 2025.
Lordship,
This cannot be used.
cannot.
How do you take care of it?
Lordship, it can be lordship after placed onto the bank, lordship. I think.
The bank again does it.
Lordship.
1 year, 6 months. Tender notice, page 16 of.
Earnest money not submit. Comparative statement.
My lord, my
1%
submission before your lordship, there is tampering.
Huh?
There is tampering in the white mark is there.
Okay, you submitted which one?
My lord.
Where is the additional affidavit file?
Additional affidavit. Additional affidavit, my lord, filed on 21/8/2025. Your lordship will be pleased to see this page 36, my lord. There is tampering. Earnest money column.
Original second month of record also I have submitted, lordship. I think there is comparative statement.
And this bank draft is a page 38, my lord. Hmm.
No. This is not tempering. This is all there. You did not submit the 1%.
So, my lord, that
Can't help it.
this
This
page,
is the chairman's minutes.
page 38, my lord,
No, this
of
is
my
not
additional
submit.
affidavit, my lord.
You see, there is no tempering here.
Earnest money column, my lord, page.
Yeah.
Six,
No,
my
forget about that. Mr. Take kindly look at it. There, that page, not that page.
No, my lord, it is written that 1% earnest money draft not submitted. That's all right, my lord. But my bank draft is here, my lord. Bank draft is there. That bank draft.
But they say that, but how do I
They
trust
have
you?
written that 1% earnest
you have to
money
prove
is
it.
not submitted. But I have submitted, my lord.
How do I know?
That is
No,
there, my
the
lord.
records does not show.
That one will be in the record, my lord. That one will be in the record, bank draft.
That is not here in record. That is what I'm
My lord, the
saying.
bank draft must be there, otherwise my tender will not be accepted, my lord. Tender I have submitted.
No. Many people send 1 month they're not deposited, 1 month draft not deposited. Many persons did not. Only 2 tenders have been received. Musalpur market, only
My
3
lord,
drafts.
your lordship will consider page 38. This is the bank draft I have submitted. Bank draft I have submitted, my lord. That is their record. If it is removed from record, I do not have to say anything. My lord, your lordship, this is the thing.
It has been removed from the record.
That is the thing, my lord. Here, your lordship would be pleased to see my document, page 38. This is the bank draft. I have drawn the bank draft, my lord. Otherwise, why I will draw the bank draft? To keep it with me.
Where is the requirement?
My lord, requirement, my lord, bank
Amount
draft
may be
requirement,
paid
your
in
lordship will
check
be in the
or
tender
bank draft in case
notice, my lord.
of failure to deposit the full amount in due time, the EMD shall forfeit it. An agreement has to be signed for so. Where is
Lord,
the earnest deposit?
Page 16, my lord. The tender must be accompanied with earnest money come security equivalent to 2% of the estimated value of general category tenders and 1% in cash, STSC, OBC. I will come to this category, madam. In the form fixed deposit with a minimum validity of 1 year, 6 months. This is the bank draft. Now, my lord, what happened? I have submitted. It is their record, my lord. If they say that I did not submit, where I will go, my lord?
Madam, tell me one thing. The tenderer must be accompanied with earnest money comes security deposit equivalent to 2% of the estimated value of the general category tenderers and 1% in SC/ST tenderers in the form of fixed deposit with a minimum validity of 1 year and 6 months drawn in favor of chairman so and so. Now, if that is the term of the condition,
my lord,
then how can you take these are not fixed deposits. These are not fixed deposit.
my lord, everything, my lord, everything on record, my lord, I have drawn the draft from bank, my lord, number is there.
What is the number?
My lord, that your lordship will turn to page 38.
What is the number?
My lord, branch is
number of the draft.
Draft number, my lord, your lordship, head office and so. Customer ID, etc. is there, my lord, but thing is this, my lord, it is a
And a
photocopy.
draft number will be there down below.
My lord. Your lordship will see page
I'm
39,
not going to see, you have to help me out.
my lord.
I can see it will only take me
Bank
one.
seal, etc. is there, my lord. It is.
Bank draft number is there. Down below. It will start with 4.
It is not clear, my lord. That's the thing.
Then how can I take into account?
My lord, serial number is there, my lord. 921193. Kromanko, serial number 2022 SSK ZA 921193.
Huh?
At the top, my lord, in
Ah.
page 39, page 39, page 39, my lord, in the right hand column, serial number, Canara Bank, my lord, serial number 2022 SSK oblique ZA 921193.
No. That's how I.
If that was drawn, my lord, what will be my purpose to do this? Bank seal is there. And it is written, chairman.
Mr. Madam,
Please to chairman.
one thing I have a problem out here. Look at this, what you have done. Does it look, isn't it done subsequently? This person's number. The number, see how it was entered. The amount which have been entered. Seems that you have opened, you knew everything.
Bank
This
draft
is
value.
done with a separate handwriting, everything different, and it is kept open. There's no mention bank draft number, nothing is mentioned, bank draft value number, not properly mentioned.
Sometimes it keep blank because how much amount later on we shall put like that, lordship. But I cannot say where what is.
Huh? Then how is it possible that you can accept anything else? If you are rejecting it, you have to reject all 3. The security deposit, you are asking for the EMD of 1%, isn't it?
Lordship,
That has to be in terms with the.
this amount is lordship tender value, lordship. We are saying only earnest money of 1%.
1%, which is in the form of fixed deposit, with a minimum validity of 1 year and 6 months,
6 months.
drawn in favor of the chairman, so and so. Isn't it?
Mosolpur. Municipal court.
Show me, is it drawn in the name of the chairman?
Chairman, Mochalpur Municipal Board, lordship. Second draft is 2000.
But it cannot be, this is in violation.
Lordship, it is in
This is the bank draft.
lordship.
You are required to submit a fixed deposit of a value of 1 year.
It is draft.
Don't calculate. If I look. You see. Yeah. Page 39 now you are referring to?
My lord.
You see, this is a bank, not a bank draft.
It is fixed
This is
deposit.
the Canara Bank, this is a fixed deposit.
Fixed deposit.
Where your entire basis is wrong. The petitioner had not submitted a bank draft. Obviously, you will submit only a fixed deposit. And this is the fixed deposit which you have not taken into consideration, it seems. Yeah, there is no draft number mentioned, date mentioned, writing words, nothing is mentioned. Madam,
Lordship.
the reason why you have rejected is wrong. Where is this document then? Deposit. Deposit receipt.
All are draft.
Page 38, my lord. Type copy and the photocopy is at page 39. Bank draft. Fixed deposit.
This is in the name of whom?
Primal, my lord. Primal Bormon, Brahmo. Primal Bormo. Received from Primal Brahmo. And in the name of chairman, my lord, that is in the seal, page 39.
Page?
List 2, page 39.
Where do I get it?
There is a round seal, my lord, above that. List 2, chairman, chairperson, Mosulpur Municipal. It's a clear document, my lord. There is nothing.
Where is the EMD required? EMD means how do you take a bank draft? You do one thing.
Lordship.
But why it is not there in the record? Is like, if that is so, then it is a serious matter.
It's a serious matter. Actually, I have deposited, my lord.
The
Otherwise,
record
why I
does
do
not
this?
show that this document.
Well,
Yeah,
that is
it
why
is
in
a
the
serious
compulsory
matter.
statement, it is written that I have not submitted. That is the thing.
Then I think we should make an inquiry.
My lord.
No?
Yes.
This is a false affidavit being filed.
If that is done, my lord, then it is very serious thing. The authority for doing something, my lord.
Here he has produced another one. See, this is the fixed deposit.
Given goodbye to everything. my
Sumon
lord.
Boro.
Document will remove.
Sumon Boro has given the this. He has given another one. See.
Date is there, bank draft with that fixed deposit drawn from bank, my lord, everything is there. Why I will do this, my lord, on 16?
Why you are doing? I'm not on that.
16,
But here it is being given. You do one thing.
Let us get that tender.
We should stay this.
Last date for filing. না বুঝিনি লাস্ট ডেট কেতিয়া টেন্ডার ফাইল করার লাস্ট ডেট কেতিয়া এগুলো তো আপডেট ফর ফাইলিং
Here is a case of losing the very document. Document will there.
The bidders has submitted tenders, the tender book. And here 17/6. Your lordship will consider one thing, 17/6 was the date for submitting tender. And my fixed deposit also of 17/6.
This is for 1 year.
Yes. And maturity also on 17/12/2026, my lord. It's a clear document, my lord. But if it is not on record, my lord, then we are helpless.
The serious inspection.
My lord.
It's
if they want to do like this, my lord, defeat the petitioner in this way, my lord, it will be a bit dangerous thing.
He has filed an affidavit also, na?
Additional affidavit. Executive officer, yes, my lord.
And he has been running since when?
1/7/2025.
25.
About 3 months already he is running.
One person draft.
If necessary, my lord, regarding my bank draft, from the bank that
You give a certificate.
information may be.
You take a certificate
Correct.
that it has been issued in the name of, pledged in the name of 12.
My lord, in that case, my lord, it may be reflected in the order which can be produced before the bank.
It's okay.
Yes, my lord.
We'll
I'll
pass on.
produce that order before the bank.
We'll pass on.
Otherwise, bank will get difficulty. And the interim order, my lord, may be passed. Interim order may be passed because
Interim order has to be
it is 1 year settlement. Already 3 months have gone.
Interim order has. And we go for an CID inquiry. But this is required. The very serious thing, if a document is being lost and not kept out here and affidavit is being filed, it is required.
My lord, for certificate I'll produce from bank, my lord, if your lordship directed me to do it in the order. And regarding inquiry, my lord, that is up to your lordship.
You have been given some other contract earlier. Earlier you were running this contract.
No, my lord.
Primal Burma, allotment of Musalpur bi-weekly market
This is the market.
for the year 2024-25. We hereby inform you that return is allotted to you, and quoted 2,62,000 so and so, with effect from 1/7/2024 to 36 as per the following terms as the regulation so and so. Earlier it was given to you.
My lord, my information is not available at this stage. my lord.
We do one thing. List this matter again tomorrow at 2 p.m. Tomorrow, I matter go. Right. List this matter on Friday, 2 p.m. On which date Miss So-and-so shall again produce the records. The learned counsel appearing on behalf of the respondent. Municipal board, na? Madam, you are appearing for the
Lordship,
municipal board?
Executive Officer, Musalpur Municipal Board.
Appearing on behalf of the executive officer of the Musalpur Municipal Board shall also apprise this court as to how the EMD of the private respondent could have been taken by way of bank draft when it is the specific stipulation in the tender condition that it has to be by way of a fixed deposit. That too having a validity of 1 year and 6 months. To Monday. The records which have been produced before this court again be reproduced, is returned today, and Mrs. R.B. Bora shall again produce the same on Monday. We dispose it of on that. In the meantime, the Mr. MSA, the learned counsel appearing on behalf of the petitioner, who is given the liberty to produce a certificate as regards from the Canara Bank in respect to certifying the issuance of the fixed deposit, which have been enclosed at page 39 of the requisition.
Obliged.
For orders item 37. That date may be mentioned, my lord, that 16/7 like this. Date of the bank deposit, my lord.
17/6.
17/6. That may be mentioned. That will be clarified for the bank, my lord. 17/6/2025.
76.
Obliged.
Yes,
Page
madam.
number 20.
Lordship, this is regarding tax sanction order, Lordship.
Do
Authority,
you passed any orders?
I have verified, Lordship, but due to some difficulty, they could not provide me sometime next week, Lordship.
Mrs. R.B. Bora submits that she will obtain instruction as to whether the order dated 22/12/2021 passed in WPC number 7152/2022. We are concerned with that, na?
Hello.
Which order?
The page number
Annexure E, na?
20, yes, my lord. Annexure C.
Passed in WPC number 7152/2021 have been complied with or not. List this matter on 2nd of 3rd of November 2025. If liberty is given to the respondent to bring on record if any speaking order has been passed in the
The application number 58822, my lord. That
Eh?
is page number 20. Page 20, my lord. Application number is 58822.
order dated.
Order dated 25/4/2022. 38, 39.
38, 39.
Cover date.
Same.
40.
Lordship, in this matter, I seek some more time to file my affidavit, Lordship. Till Monday, Lordship. Till Monday.
Mr. Sri Sharma submits that the affidavit would be filed
Last time also I sought for some time.
on or before 26th of September 2025.
Yes, Lordship.
To establish the matter on 17th of October 2025.
But you are.
Same.
Same, Lordship.
Same.
But in this matter, we have filed our affidavit.
List this matter on 17th of October 2000.
Obliged, Lordship.
Applied.
Lordship, partly that 5 lakhs rupees has been
But my instruction is that lordship payment has not been lordship. Pursuant to earlier order of lordship dated 18/8/25, the petitioner approached the authority on 26/8/25. But I talk with 415 lordship, payment has not been made.
Yes, when are you paying the remaining amount? So what is the chronological list? Is it 115?
Yes, Lordship.
File an affidavit. In the chronological list, what is the state?
Yes, Lord.
Huh? And 5 lakhs have been paid.
So 5 lakhs, Lordship, in the second page of the instruction that Lordship, it has been revalidated on 15/9. That was only on Monday, Lordship.
So what should he do?
Lordship,
How will he get the money?
Lordship, he will be getting it within, maybe within 2-3 days, at the most, 1 week, Lordship. Because on 22nd, the elections are
Chaudhary,
there,
appearing
Lordship.
on behalf of the BTC submits that within 1 week, the petitioner is the amount of rupees 5 lakh would be transferred as per his instructions. List the matter on 26th of September 2025 for an update. Full stop. Just quote further. Full stop. Just remind me this, as regards 22 lakhs on the next day, I'll pass an order. Huh? The Mr. B. Chaudhary has placed an instruction dated 16th of September 2025, which is kept on record and marked with the letter X.
May I please, the Lord? Here we have filed an additional affidavit today, my lord.
You have filed?
Additional affidavit, my lord. My lord wanted to know the, my lord, the scheduled land which is we have purchased, my lord. The lessor has purchased or the lease land is the same or not, my lord?
Why the matter has come up for orders?
But in the
No
last-
further affidavit has been received. That is why you filed it today.
Today, my lord.
Then? Okay, Mr.
Yes, sir, Director.
Who appears on behalf of the petitioner who submits an additional affidavit have been filed today. So the same is not on record, list the matter along with the same after 4 weeks.
My lord, there is an interim ornament.
List the matter again on 12th of November 2025. The interim order passed earlier shall continue till.
Lordship. I'm deeply obliged, my lord.
44.
Lordship, we have filed an affidavit, your lordship. The amount claimed by the petitioner 64 lakhs. We have admitted an amount of 25 lakhs.
Now, payment? You have admitted?
Yes, we have admitted only an amount of rupees 25 lakhs,
This is
62,000.
only an amount of demand and not the amount claimed. So I have asked you to file an affidavit. Have you filed it?
Yes, file it, lordship. They have received it.
Okay, Mr. R.R. Gogoi, the learned standing counsel of the PHE, submits that the affidavit has been filed on behalf of the chief engineer PHE to the effect that the petitioner is only entitled to an amount of rupees 25 lakhs 60,883. First of list as the said affidavit is not on record, list the matter. You want to file a reply?
Lordship.
List the
Lordship.
matter again on.
Lordship, the admitted amount may be paid to us, Lord.
No part per payment. Okay, if you want to file a reply, we'll see on the reply. We listed again on November 17th of November 2025. In the meantime, the petitioner is given the liberty to file the reply.
45.
What is this IA for?
This I is for trial of a case.
What?
Trial of a case for perjury, lordship. We have
I
this
for what?
application for trial of an appropriate proceeding for perjury, lordship. However, lordship, the office note says that AD got an answered notice, but it seems.
Who is appearing here?
It's appearing.
I
You're
am
appearing?
appearing in the contempt, my lord, but I have.
Are these the persons who are there in the contempt?
He is appearing for respondent number 4, I guess.
You file your reply.
We'll
in this
file it,
IA.
my lord. We will file it.
to file it because this is very serious allegations being made. Mr. Ibotakur appearing on behalf of the opposite parties in the instant application. 3 weeks time for filing the reply. To establish this matter again on 31st of October 2025. The affidavit be filed by 22nd of October 2025. Liberty given to the petitioner to file reply, applicant to file the reply if advised.
May I please the lordship? This is a contempt case for non-compliance of order dated 13/5/2000.
Which department?
PHC, Lord. PHC BTC.
PHE BTC.
Yes, Lord.
You are appearing?
We have filed a power for Principal Secretary BTC today, Akasdeep.
Miss R.B. Bora appears on behalf of the respondents. Holder,
No, Lordship, only Principal Secretary BTC.
huh?
Akasdeep.
On behalf of the respondent number 1. It is further seen and she submits that some time may be given for filing the reply. As regards the respondent number 3, 2 to 4, the service is not complete. List this matter again on 10th of November, 14th of November 2025. In the meantime, the respondent number 1 shall bring on record the stand by filing the affidavit, and the other respondents and the registry shall submit a report as regards the service in respect to the other respondents. Service not complete.
My lord, BTC authority has filed my lord affidavit. We will file my lord reply my lord on my lord tomorrow, my lord. I cannot be posted on Monday, my lord. Some urgency is there. There is settlement of
What
fishery.
is this?
This is regarding settlement of fishery. Private respondent has been given the settlement. By cancelling the earlier settlement process in which I submitted the bid and I am found to be the highest bidder.
Oh, yeah.
That notification may not be applicable in this case, Lord. That notification, Supreme Court notification.
Huh?
Supreme Court order may not, I don't know, may not be applicable in BTC.
In this case?
In this case, because this fisherman certificate, there is 100% SC community is there in our case, in government case. In their case, we have transferred the fishery to them.
No, this is not on that. This is on something else.
Yes. Now regarding tender part, I'm.
Here he has said his was rejected on the ground that it is excessive.
My lord.
He is not participating in the tender. Huh?
They have filed the affidavit.
They have filed affidavit. Yesterday.
Miss R.B. Bora submit.
I will respond it tomorrow, my lord.
The affidavit has been filed on behalf of the respondent numbers 3, 4, and 5. Mr. M.E. Mondal submits that he would like to file a reply
By tomorrow.
by Friday to establish this matter on 25th of September 2025.
Development.
The registry shall bring on record the feelings.
If you are.
If you don't file, Mr. Mondal, it will come up for orders.
Propositively, I will
Come
file
in
it.
for orders, there the problem will
I will
arise.
file it tomorrow, Vice.
And the service is complete or not?
Yes, Dasti has been taken and I will also file additional evidence tomorrow, my lord, regarding Dasti.
We have not taken.
Dasti steps has been taken, my lord.
Okay,
We'll file additional affidavit tomorrow.
40?
51.
51, yes.
In this matter, I have already taken all the steps.
Service upon 7 and 8 is complete.
Yes, Lord Sir. But Lord Sir,
Service upon
I'm
the
unable
respondent
to
number
file
7
that.
and 8 being complete, list the matter for admission immediately after the vacations.
There's a direction filing affidavit regarding Dusty service, Lord Sir. But I am unable to file because the original service.
It's okay,
not
service is complete.
Yes. Sir. This is the receipt copy Dusty service.
Accordingly, list the matter for admission. on 17th of November.
Obliged.
52. May it please the Lordship. Lordship, office note dated 16/9/2000.
What has happened?
My lord, we have made 8 respondents. Now, respondent number 4 is not reflected in the CIS.
Huh?
Office note, my lord, 16/9.
Understood. What has happened?
Therefore, my lord, they could not.
Respondent number 4 is not reflected, whereas as per the petition, there are 8 respondents in the case. The name of the respondent number 4 has not been entered in the CI.
Yes.
So it is for the registry to do the needful. Today the date fixed.
Yes, yes.
Oh, no interim order.
No interim order, my lord. Interim,
Why?
the last date, my lord.
I gave a short date because of that. Oh, yes. This is the matter pertaining to that Numaligarh repair.
Yes, yes.
Well, have you served it?
No, no,
Dusty?
my lord. I have taken the steps. I have placed the Dusty, my lord. But Dusty, they could not, my lord, they release due to this, my lord, due to this CIS, my lord, effect.
Goodness. I've also said that take the service upon the response through at the address of the respondent number 1, because it is
Yes,
here.
yes, it is in Piston Posting.
Yes. So therefore I allowed it.
Yes.
to stop. This court have duly taken the office note dated 16/9/2025. And it surprises this court that on account of the fault committed by the registry, the petitioner have not been able to effect service by way of Dusty. The registry shall do the needful forthwith and correct the same in the CIS. And further, list this matter again on 26th of September 2025. Full stop. The petitioner is given the liberty to take steps by way of Dusty upon the respondent numbers 1 to 7 at the address of the respondent number 1 on or before the next date.
Can we have it on 25th? Can we have it on 25th?
Why?
On 26th, my lord, my senior.
Okay, after vacation. After vacation. Because you have to see there are so many matters. I already have 25, so many matters. Okay, 25 good.
I am deeply obliged.